which is the paperwork that I just read the other day. Yeah, 2 court dates, 6th and 9th. Okay. Yes. Okay, so let me pull up the transcript. Now, you guys, the transcript is long. It's 113 pages. Not all of it is, there's a lot of like blank pages and whatnot in there. All I ask you guys, again, you guys never have to gift me if you guys like to. I appreciate it. But if you guys can tap the screens, keep it cute in the comments. We always want to make sure that I leave comments on, even though I will not be in the comments because we will be reading. Keep it cute in the comments. It's okay to have differences of opinion, but again, I want you guys it all to be respectful. To drop your daily heart means if you can, I definitely appreciate it. And if you start to notice it slowing down or whatever, certain individuals don't like my page, and whenever I read anything about them that shows what they're putting out is misinformation, she likes to come over here and what's it called? Report my page, right? And so we can try to help avoid it being reported by the activity, right? The taps, the likes, the shares, the comments, the gifts, etc. Yes, love.
You and I both at the same time. So I haven't been on today, but has Bree and Sandy been posting, and have they made it back to the States, or are they still in Paris?
I have no idea. I haven't been on it all either. People are garbage. Hello, pretty Jackie. Dana, that's the other thing. I'll answer that question because I know it's going to come up a million times. I have no idea if it's really a boy. Let's not forget, the majority of things that they do is not true. It's to gain a reaction, right? When she did W's gender reveal in Paris in front of the Eiffel Tower, she said it was a girl. Well, we all know that W is not a girl, so we don't know. It's all. Thank you, Renee. It's all just one of those things. So, we don't know. Okay, so what we're going to do is, so Bailey, I'll read the judge. Oh, once again, can one of my mods undo this whole, when Spicy, she had a girl? Yeah. That's exactly what I think, Sparkles. If she is pregnant, it's probably a girl. She just doesn't want people to know. But we have that thing again where it's whatever it's called, filtering. It's doing a filter where it wants it to be approved. I don't know how to turn that off. You haven't missed anything, Tiffany. We're just getting started. Okay, so I will be the judge, Bailey, and then you want to be the attorney?
Yeah.
And then, so I'll be the judge and the witness, and then you'll be the attorneys.
Perfect. And then I don't know exactly what time it is for you, but it's 7:19 for me.
Yeah.
And I'll be home right about 7:35. Okay. So in about 15 minutes.
No worries. So I'll just read along, and then you can pop in and join whenever you're ready, whenever you're home. Sound good?
Okay, perfect.
Okay. So again, for those of you guys just joining, once I start reading, I'm not going back. This is the transcript from October. Okay, so this is not new. This is the transcript. We are going to read word for word what the judge, the attorneys, Kate, Bree all said for this 113 pages. As I'm reading it, some of the times it's going to sound like I don't know how to read. Okay. But that's not the case at all. I'm reading verbatim exactly what it was that it said. This says October. Oh, the court date was October. It's October 17th, but the transcript is from August. So this is a hearing date for October, but it goes into the August transcript. Thank you. So I'm going to read it. And again, it's verbatim. This is not me or Bailey's thoughts, opinions, whatever. This is their exact words. We will read it exactly like they do. Hi, WV Mama. Hey, Kim. Okay. So this is from October 21st. Declaration of Respondents Counsel RE lodging of 827 court reporters transcripts. Yes, all of this will be posted over on YT. So I'm not going to read that because that's just saying they're going to do this. Okay. This is from when they were in court in August, their trial. So this is from their trial time. Let me get to the right page. See, it's 113 pages, but we're already on page 9. Okay, you guys ready? Here we go. So I will be staying out of comments, but you guys can continue to comment to each other. Please make sure you guys tap the screen, whatever, do all the good things so I don't get blocked. Okay, appearances. Petitioner being present. Petitioner John, respondent Bree. John present, represented by Taylor Butnick, attorney at law. Respondent being present, represented by Lindsay Fonseca, attorney at law. The judge. We're back on the record in the Giese matter. Can the parties make their appearances again because we have a court reporter? Miss Budnick. Sure, Taylor Budnick for the petitioner, John Giese. He is en route. I will waive his appearance so we can get started until he comes in. The judge. Okay. Miss Fonseca. Lindsay Fonseca for respondent Brianna Lynn Olson, who is present and currently sitting in the witness box. The judge. And Miss Fonseca was very busy over lunch preparing. Miss Fonseca. My paralegal. Random. The judge. Your paralegal was very busy over lunch preparing the transcript. Have you had a chance, Miss Budnick, to at least look at the video? Miss Budnick, again, John's attorney. I did actually. I have much more information now after the lunch break. The judge. Mr. Giese, if you can join us with counsel. All right. I assume you're going to be playing the video, correct? Miss Fonseca. The judge. And we're going to get the computer up. All right. So now what are we going to market? Did you know what your next line is, Miss Fonseca? Want to make it FF? Miss Fonseca, no, I have spots left for it. It would be HHHH. The judge, 4 H's. Okay, Miss Fonseca. And we are on both sides going to go through the end and mark and move everything since we weren't doing it as we went, right? I'm going to read that again because that was a confusing statement. And we are on both sides going to go through at the end and mark and move everything since we weren't doing it as we went, right? The judge, sure. Miss F, okay. The judge. So you're going to be playing something that you marked as HH. And note Miss Budnick's continuing objection, and I'll hear more from her once. So you're going to play the video, HHHH? Miss Fonseca, Exhibit HHHH is marked for identification and played in open court and not transcribed herein. I so wish we could hear it. Miss Fonseca, I just call her Miss H. That is Bree's attorney is Miss F. Miss F is Bree's attorney. Miss F. And then just so you can see the date, the judge. Okay, so are you going to ask your client some questions? Miss F. Yes. Redirect examination by Miss F. So now she's asking Bree questions. I will go through and be the attorney and Bree in this situation. Question, Brianna, is this John's TikTok page? She answers, yes, it is. Miss Budnick, John's attorney. I would object on the same basis. The court, lack of foundation. Miss Budnick, yes, lack of foundation. Miss F, he's already testified about his online TikTok page name. The court, let me see it again. Hold on. Miss F, and the court, hold on. Miss F, went through the court. No, but counsel, you can't. A person who doesn't maintain that page cannot testify that is indeed his official page. She can testify that she has seen it, seen videos in his name, and that's the most that she can testify. She didn't create it. Miss F. Right, the court. Okay. So that, let's put it back up so I can see. Miss F. The whole page, or is it is a little confusing right now. Once Bailey joins in and she's able to help me read, it will be a little bit easier because then there'll be two people. These are, you guys, these are the transcripts from Bree and Court, Bree and 2K's trial. This beginning stuff is kind of like just information, but there's some good stuff coming up that we kind of skimmed over last time. But I am trying to make it, Budnick is 2K's attorney. Miss F is Bree's attorney. Hi, Angel. Okay. The judge. Okay. You recognize what that is. Everything in there? Do you see the 2K on top? What does that appear to be from your understanding? Bree says, that appears to be an on-screen social media name. The judge. And you know that because you've watched multiple videos or you've seen videos affiliated with 2K? Can you just push it down a little so we can see the top? It says 2K at the top. Have you seen other videos on that top page depicting Mr. Gacy? Bree says, yes. The judge. And you've watched other videos depicting Mr. Gacy on this page? Bree said, yes. The judge, okay. Miss F, Bree's attorney, asked Bree, and did you hear the lyric about the X? They're talking about the song. Okay. Bree says, yes. She says, the attorney says, do you understand that to be a lyric about you? Thank you, Angel. Bree says, yes. Why was that your understanding? Bree says, because he said publicly and personally to me that I've been the only girlfriend he's ever had, so I would be his only ex. Bree's attorney. And you testified earlier that the first time you saw this video online was the day before the custody dispute. Bree said yes. The judge says, and when you refer to that, you're specifically referring to that line on 23 seconds where he says, okay, my ex in the place, she gonna pay for that shit. Is that what you're referring to? Bree says, yes. The judge says, okay. Miss Fonseca says, okay, so back to the date of March 25th. So you said earlier that nobody came to your house on the 24th to serve you with orders, correct? Bree says, correct. Her attorney says, and the same thing the morning of the 25th. Bree says, correct. Her attorney says, and when, in the clips that we saw, when you noticed that the police were outside, who were the men that were talking in the room with you? She says, those were my managers at the time. Her attorney says, and can you give, I guess, just their first names? Bree says, Jordan and Itai. Her attorney says, were they instructing you on what to do with the police encounter? John's attorney says, objection, leading. The court says, overruled. Miss F. Were you listening to their instructions during the police encounter? Bree says, 100%. And why were you listening to their instructions? Bree says, because it was kind of like under their supervision. It was their house. They were my managers. I was trusting them what they were saying. Bree's attorney asked her, and earlier, when Miss Budnick asked you if one of the clips where we heard a female voice on the phone, she asked you if you were talking to a lawyer. Were you talking to a lawyer on the phone in those clips? You guys remember what we're talking about, right? This is when the whole kidnapping thing happened. Baby W was at the MILF house. Remember, she was on the phone with someone who at the time she was claiming was an attorney. Remember? Okay. So she just asked, don't do that. Don't do that. Okay. Were you talking to a lawyer on the phone in those clips? She responds back, no. Do you know who that person was? Bree says, I think it was a family friend of my manager, Jordan. Her attorney asks, was that person given Jordan legal advice? John's attorney, objection. The judge, hearsay. Ms. Budnick, hearsay, lacks foundation, relevant. The judge, sustained. Ms. Fonseca says, question. Were you listening to the instructions from the person on the phone? Bree said yes. Which we also know wasn't true because she told her to. But anyways, I'm just going to read it. Question. Did you have a lawyer of your own to call at the time? Bree said no. Question. And did you believe that you were doing the right thing listening to that lady's instructions? She said yes. This is the judge. Are you going to try to assert some kind of defense that there's a defense to this because she did? She was listening to somebody and somebody told her to do it. Is that what Ms. Fonseca, Bree's attorney, says? No, I guess this could be impeachment or just addressing their testimony of them trying to say that this was all done intentionally to get a rise out of John. The judge. I see what you're saying. So this is impeachment of the claim that they introduced that she did this intentionally to get Ms. Fonseca correct. The judge, okay. Ms. Fonseca, and because again, it was their videos of this whole streamed incident where we have all this crosstalk that they have now put into transcripts and put before the court. So I know it's hearsay, but how she interpreted it is technically not. The judge. The only thing that I paid attention to, again, for the truth of the matter asserted, are statements that Miss Olson said. Miss Fonseca, The judge. So I believe there is a statement in there to the effect of she did this to get a rise out of. So your testimony that she said about listening to someone potentially could impeach that if it was done intentionally. Miss F. Oh, you're talking about the pod, the later piece. Okay. The court says, I think. Ms. Fonseca, yeah, you're talking about the podcast. Yes. Ms. Fonseca goes back to your questions. So let me break this piece down. Bree's attorney is trying to state that her doing all of this was not to cause a rise out of 2K at all. She had no clue that she wasn't supposed to take baby W. She didn't know who that person was on the phone, if it was an attorney or not, but she fully believed that her managers wouldn't steer her wrong, and that's why she just listened to them. Only problem is she then went on to a podcast, and the judge, that's why the judge called her out on it. She went on a podcast and said she did it to get a rise out of John to piss him off. So that's why the judge brought that up. Oh, yeah. No, the judge knows. That's why the judge called her out on it. Okay. So you're back to Miss F. And because again, it was their videos of this whole streamed incident where we have all this crosstalk that they have now put into transcripts and put before the courts. So I know it's hearsay, but how she interpreted is technically not. It's about so it's hearsay, but that's not the way that Bree interpreted it. So we should just let it fly. The court. So I believe there is a statement in there to the effect that she did this to get a rise out of John. So your testimony that she said about listening to someone potentially could impeach that it was done intentionally. That's where she's talking about the podcast. Okay, so we're back to your questions. Question from Bree's attorney to Bree. So I'll go to the podcast then. So the podcast that the judge just mentioned, when was that podcast filmed? Bree says, sometime in 2025. Question, was your testimony earlier that you had a script for the podcast? Bree says, they did provide me with a script, yes. Stop it. Her attorney says, who is they? Bree says, the people who run the podcast. And did you have to follow the script during the podcast? Bree said, yes. I wonder if she knows lying under oath is like against the law. Because this is, again, I think last time we were just like reading the words, right? There was 4 of us doing this. We were just kind of reading the words and the motions. And now I'm going through this and I'm like, wait a damn minute. Yeah, she's clearly lying. Okay, it gets better though, guys. This is just the tip of the iceberg. It gets way better. Question. Do you know what would happen if you didn't follow the script? John's attorney, objection, speculative, the court, that sustained. Question from Bree's attorney. Okay, do you recall John testifying that last November you took W from Texas to California, or was it reverse? I'm sorry, I just don't remember. Bree says, I remember that. From California to Texas. From California to Texas. Okay. And last November, when that occurred, did John file an ex parte motion over that incident? Bree says, no. Did John release a music video last November by chance, to your knowledge? Bree says, no. Did John file a restraining order last November against you? Bree says, no. Do you recall seeing the clip that Miss Budnick showed earlier today, where you're wearing sunglasses and talking to your chat about kidnapping? Hello. Bree says, yes. Were you being serious when you said, I'm going to go kidnap my kid? Miss Budnick, objection, leading, the court, sustained. Bree's attorney, were you being serious as to any comment you said in the clip that Miss Budnick showed? Objection, leading, that's overruled. Bree says, I can answer. The court, yes, sorry, overruled means you can answer. Bree says, no, I was actually repeating comments that I was seeing come across my screen. Miss Ebb, okay, I don't think I have anything else. The judge, okay, Ari, Miss John's attorney, just a couple. So now we're going into, John's attorney's cross-examination of Bree. Chelsea, I believe she does. I absolutely, truly believe she does. After rereading all of this, or some of this, again, I didn't read all of it, but after rereading some of this, I'm like, oh, she thinks everybody is an idiot. Oh yeah, grab the popcorn, get some snacks. We're going to be here for a while. We're only on page 18, and it's about to get good. Okay, here we go.
I'm just pulling up.
Oh my God, scared the crap out of me.
Sorry.
You guys know how I am when things just randomly pop in. I was so into it, I forgot you're even up here. Okay, perfect. I'll start reading and then let me know when you're ready. For those of you guys that are just joining, this is the transcript from Bree and 2K's trial back in August. We read them back in September, October when they came out. But we're rereading them because with everything that has come out now, a lot of this stuff makes a whole lot more sense now. So we're going to reread them before they go into trial. I'm going to stay out of the comments. Bailey's going to, when she gets settled, she's going to pop in and it will be a lot easier going back and forth because we'll each play a part. Okay, cross-examination. This is from John's attorney. You had testified before the lunch break that this music, the song that you have discussed Mr. Gacy posting to social media in March of 2025 referenced Mr. Gacy using rugs, and you described Tesla as sort of, I guess, a slang word for a rug, correct? Bree says yes. The actual lyric is "Ain't poppin' no Tesla," isn't it? The judge says, "Can we look?" What? Bree says, "I wouldn't know. I would not know." Miss Budnick says, "It's page 2 of the transcript. It's the very last sentence of the first paragraph." The judge says, "Do you want to look at it? Do you have the transcript?" Bree says, "Is it the big one?" Stop it. Miss Budnick, no, it's the judge says, "I will give you mine. It's on the second page, top of the paragraph." Bree says, "Okay." And so if you look at the very last sentence of the first paragraph of the second page, it's on the right-hand side. Isn't it true that the actual song lyric is "Ain't poppin' no Tesla"? Bree says, yes. She says, okay. Isn't it true that this is a song from early 2025? Bree's attorney objection, lacks personal knowledge as to when John produced the song. The judge, have you ever seen this song prior to March 2025? Bree says no. The judge says, I guess, heard the song prior to 2025. Bree says no. Miss Budnick, have you seen the music video prior to 2025? Bree says no. Have you heard the music video prior to 2025? Bree says no. And he doesn't reference you by name in this song at all, correct? Bree says no. He doesn't reference any children in this song at all, does he? Bree says, not the part that I heard. Like she didn't hear this whole song. And you testified that some of the men in the March 25th, 2025 live stream, you named them Jordan and Itai. They're your managers. That's not accurate, is it? Bree says, it is accurate. Wasn't Itai your boyfriend? She said he was not. She says, so you were never in a relationship with Itai? Bree says, no. The judge says, how old are they? Do you know? Jordan and Itai. Bree says, 22 and 21. This is the judge, can I assume that neither one has a legal degree, correct? She says, correct. Miss Budnick, thank you, I have nothing further. The court, anything else? No. May she rejoin me at the counsel table? Yes. Not the boyfriend? Not the boyfriend? The same one that she claimed? Right. The same one that she claimed she used her boyfriend paid for her attorney fees? That was Itai that tried to do the chargeback? Y'all, she just be lying. Okay, Miss Olson rejoins counsel at the table. This is the judge. All right. Are you calling another witness? Miss F says no. The court, okay. Are you going to call your client in rebuttal and then do evidence? Ms. Budnick, yes. Just very, very briefly. The court, sure. Mr. Gacy. And then Ms. Budnick, John, the court, do you want me to leave the transcript or are you going to use this? She says no. Okay. So now this is direct examination to John from his attorney. John, is there a difference between your professional personality and what you are feeling in your personal life? John says yes. What is the difference? John says, well, online I smile through everything and I get through it the best I can. I have a son looking up to me. Social media is my job. I'm not going to go in there showing fear, and especially if someone's admitting that they're trying to get a rise out of me. Why would I show that somebody is getting a rise out of me? If someone is trying to put fear in my heart and I'm raising a son, I'm going to raise my son just how I am. I'm not going to show anybody that I'm stressed out. I'm not going to show anybody that they've put fear in me. I'm not going to show that I'm scared. It's my job to show up to work and not show this emotion, just like everybody has a job to do and they go and they do it and not get emotional. They have to get the job done. Miss Budnick. Okay, I have nothing further, Your Honor. She asks anything further. Miss Budnick does cross-examination. So here's a cross-examination from Miss F. She asks, after you got W back, oh God, scared me again.
Sorry, I'm back and I have it pulled up. I just don't know exactly what page you're on.
Okay, I'll finish up this section, the cross-exam, and then we'll add you in, okay?
Okay, perfect.
Okay. After you got W back on the 25th, you sent him with your mom to Texas, correct? Miss Budnick, objection. This is outside of the scope. The court sustained. Nothing, Miss F. Nothing further. That was your only question. Okay, you can resume. Mr. Gacy joins the counsel table. Okay. So Bailey, I'm on page 22.
Okay.
Line 17. So right after it says on 15, it says Mr. Gacy rejoins counsel at the counsel table. You see
Okay.
it? Got it? Okay. So I'll continue to be the judge. I'll be the judge and the witnesses, and then you be the attorneys.
Okay, perfect.
So if both attorneys are going back, you'll just have to let us know which one it is. Okay, so you guys got that? So now when we speak, I'm going to be the judge. And then if a witness is talking, I'll be a witness. And then Bailey is going to be both attorneys. She'll just let you know which attorney she's going to be at what time when she's speaking. This will speed it up and hopefully make it a lot more sense. Okay. All right. Are you offering any other witnesses?
And then this is Miss Budnick. No, Your Honor.
Anything else, Miss?
Miss Fonseca? No, ma'am.
So do we know what to go through all the exhibits? And then I'll give each one of you an opportunity to argue.
Miss Budnick, that's perfect.
I appreciate everyone being so conscientious of time today so we can get through everything much easier.
Miss Budnick, so do you want me to just list exhibits that I used?
Judge, yes.
Miss Budnick, so let me pull my exhibit list up for this. Give me one moment.
Can we do it in numeric?
Miss Budnick, right.
And then I'll hear Ms. Fonseca's objections to individual. Let me ask a global issue to Ms. F. As it relates to pretty much all of the video evidence that she sought, including the clips, and I will tell you again the only thing the court because I know there was a lot of hearsay and back and forth, there was potential crosstalk. Do you have, are there individual ones you have objections to? Do you have all of them? I'm interested to hear what your position is as to them globally first, and then I can take them individually.
Miss Fonseca. There was just a few, and I'm trying to stay, to be fair, trying to stay within the confines of our joint statement.
Sure.
Miss Fonseca, because we did mutually agree to things in advance before we saw each other's stuff, but that's just what we did.
And I appreciate, the court appreciates you both.
Miss Fonseca, so there was, I think, maybe 3, and as she goes through them, I can speak up to which those were. That were completely third party streams or content that do not fall within the exceptions of our joint statement.
Okay.
Miss Fonseca, but the rest of them are probably fine, but I have them marked, so as she goes through them, I'll say,
Wonderful.
Miss Fonseca, sure. Miss Budnick, so, and then this is Miss Budnick. So I have all of the portions of Exhibit 64.
Well, can we start numerically?
Miss Budnick, yeah, let me go in order. I have Exhibit 16, which we, I think, already admitted.
Wait, what is 16?
Miss Budnick, my client's DVRO request. Miss Fonseca, that one, yes, we did admit that.
So the DVRO 16, which includes his declaration, and that came in intentionally without objection?
Miss Budnick, correct. And then Miss Fonseca, correct.
Okay, that's admitted. Exhibit 16 is admitted into evidence.
Miss Budnick, I have mine in reverse order, so give me a second to sort through them. Okay, I have 31.
Any objection?
Miss Fonseca, looking, yeah, that's one of the third party ones. That's Valet's TikTok. This is the one in the kitchen where there's 7 bait people all chattering at the same time. So the requirement under the joint statement to bring in third-party content like this one was that there was a nexus drawn between client directing the third party to harass or threaten. Then Ms. Budnick, that's not accurate. Our stipulation allows threats by a party to be admissible, even if they are made on a third-party social media account. This is a recording where Brianna says, "No, I just said I'll piece his mom up any time of the day."
Sorry. Okay, the judge. I want to read that again. This is a recording where Brianna says, "No, I just said I'll piece his mom up any time of the day." Sorry, I just had to read that again. Okay. This is the judge. All right. So the way I see it is, just so you all know where I heard with 1 or 2 exceptions, which I'll talk about when I make my ruling. I saw very little of any evidence that Miss Olson was directing other people to do this. There were 1 or 2 exceptions, but I think, and most of them, it sounded like people were doing it on their own, including Santos. He was all there. They were all doing it, kind of their own violation. But that doesn't take away from the fact that specific statements of Miss Olson, specifically, "No, I said I'll just piece his mom up any time of day." Those were her words. She also said I made his mom cry several times. I don't know what the basis of that. I mean, it's hearsay, but it's offered against her and she's a party client. So what would the basis of the objection to the what or sorry. So what would be the basis of the objection to that?
Miss Fonseca said, relevance, not a CHRO with mom.
I understand that. I'm going to overrule. So 31 comes in really only. It's really her comment of, I made his mom cry. And it said, I'll piece his mom up any time of day.
Then Miss Fonseca, my other concern is I think the smaller numbers were in the grouping from Friday and all the transcripts per what you said and what I also acknowledged about the transcripts were grossly wrong. So any exhibit, and we weren't presented with corrected transcripts of anything that was shown on Friday. Then Miss Budnick, they were not grossly wrong. That is not an accurate statement.
The judge, well, they weren't 100% accurate because they were transcribed by AI as opposed to a human. But I will say this, I went through them and was very meticulous when they were inaccurate and I corrected them. So, for example, on this one, the friend said, "Are you nervous?" And then there's a reference to "and 30 babes." But I don't really, in this particular case, care what the friend said. I heard nothing that was inaccurate as to, oh, I made his mom cry several times. I just said I'd piece his mom up any time of day. Now, what's introduced is not the transcript. What's introduced is the actual video. So that's the clip she's introducing. So that's overruled, okay?
Then Miss Budnick, and I missed one. Exhibit 26 was where she talks about John's mom saying she needs to do something with her fat ass. Get a fucking 360 lipo, BBL, fat back transfusion. She's not gonna do shit. She's not gonna do shit. I believe Miss Olson testified at least that some of these comments she did in fact say.
Okay, where is that one?
Miss Budnick, Exhibit 26.
Okay. Again, from a relevant stand, that's the one where it was inaccurate, where the transcript said a rack, okay? And I heard, okay, man, run it, okay? And then it was, I will, period. Because the original transcript was, I will fuck his mom. Just kidding, TikTok. I didn't, TikTok friendly. I will have his mom. I wonder if that's Etai, but the way I heard it was, I will period F his mom. No, you need to shut the F up. You need to shut the F up, dead ass. You know what? Again, I understand Ms. Fonseca's objection regarding relevance of the mom's comments. The comments about the mom. Comments about the mom that are potentially defamatory are completely irrelevant. A, because I said before, I don't believe defamation is the appropriate basis upon which to judge this because they're First Amendment rights and given that they are public figures. However, there have been allegations of threats, and it's threats. There are transcripts that shows allegations of threats made by Miss Olson both toward Mr. Giese as well as towards his mom. So I sort of, and then she said she was joking. So to the extent that this video talks about threats to his mom, though I'm not really sure, because here's where it says, I will F his mom, it was inaccurate. it says, I will period F his mom. I don't know. The relevance portion is, no, you need to shut the F up. No, you need to shut the F up. Dead ass. That may eventually, that could be seen as a threat.
Then Miss Fonseca. Okay.
The judge. So that part is relevant. Exhibit 26 is admitted into evidence. Really quick before we go on, I know it's got to be confusing for you guys listening because it's confusing, at least for me reading. It seems like they never finish sentences. Like, I want to read this part up here. I sort of, and then she said she was joking. Like, I'm literally reading verbatim, word for word, what they say. They seem to like start sentences but never finish it. So that was 3 sentences that started and never finished. So it's confusing. So I just want you guys to know again, for those of you guys coming in, it's not us that doesn't know how to read. It's that's just how it is in here, you know. I don't know if it's redacted because the redacted stuff usually will be marked out. Could be, I don't know. Okay.
I feel like it's someone with ADHD that can't, like, has that 20 different things going on in their head and they're spitting it all out at once.
Yeah, it's across the board. Yeah, it's crazy to me to be like, in that sentence, let me see. I want to F his mom, or I will F his mom. I was all period of his mom. It's irrelevant. No, shut the fuck up. Shut the fuck up. She says all that, but then she says she's kidding. Like, oh, you were just kidding. All those threats, you were just kidding. Oh, never mind. You're fine then. Don't worry about it. No, what do you mean? That's crazy work. All right, let's continue because we're going to be here all night. We may have to do this in 2 nights depending on how long we go. Okay, so we're on line 24, Miss Budnick.
Yep. And just so the court is aware, one of the other acts that can be enjoined would be harassment. And so I think some of these messages, coupled with the threatening conduct, it shows the level of harassment that my client has been going through this year. And so that would be my other argument as to why it is relevant.
The judge, harassment? And that's why I hope maybe after the break, you can come back with some case law specifically. But again, I've tried to find every single case that I could find of DVROs in the sort of First Amendment Facebook posting kind of thing to read. My understanding, as it relates to harassment, I don't know. I'd like for you to look. My sense is when they talk about harassment, they talk about direct activities, annoying phone calls, direct text messages, emails, things that are directly conveyed to a particular person. I heard testimony that he blocked her. I never heard any testimony throughout his entire time that we've been together for 4 days that she made any, other than some communication about W, which were very polite and professional on both of their parts. I never heard any testimony of her texting him, emailing him, any sort of direct harassment. There is only this sort of vague vein of potential threats made, and she posted with maybe an understanding or maybe not an understanding that he would see this. So I'm not sure. And that's why I ask that maybe at the break you bring me if this would necessarily, because those cases that I read that talk about the use of social more like texting, emailing, social media. It's a direct contact. It's an annoying phone call. That's where the harassment is, I think. So I would maybe not. I would ask you to maybe cite me some case law that you could tell me it may be. It may not be. I'm not sure, but I'll let you argue. Oh my God. So, okay. Ms.
And
Budnick.
then Miss Budnick, okay.
The judge, go ahead.
Then Miss Budnick. So the next exhibit would be Exhibit 31, which we just talked about.
And you object to that, Miss F?
And then Miss Fonseca, oh, Ballet's TikTok, yeah.
Okay. That comes in at number over respondent's objection. Exhibit 31 is admitted into evidence.
And then Miss Budnick, my next exhibit is Exhibit 34.
Miss Fonseca?
Miss Fonseca said, that one's fine. That's the boat one.
Okay, that comes in. Number 34 is admitted into evidence.
Then Miss Budnick, okay, the next exhibit is Exhibit 60, or I don't even know where I got that from. The next exhibit is Exhibit 35.
Which one is that? How does it start?
Then Miss Budnick, it says, we don't call him 2K anymore. We call him 2Gay. And I guess, my, in anticipation under relevance objection, my argument is that I do think this speaks to the harassment conduct and also conduct that disturbs my client's peace. Then Miss Fonseca, relevance. Because of how forward the court was about this topic and a couple others that were brought up in the first day of testimony, we didn't go into this because it was labeled as defamation. So relevance.
Isn't that defamation?
Then Miss Budnick, not necessarily. I think it could be harassing also, and it can be conduct that destroys somebody's home.
It's defamation. Didn't we have a long conversation about defamation and the case law?
Then Miss Budnick, just because something may or may not be defamatory doesn't make it, they're not necessarily mutually exclusive. Something can be both harassing and defamatory, disturbing and defamatory.
So, do you have case law for that in this specific context of social media posting by public figures? Because there's a lot of case law in this area.
Then Miss Budnick, specifically social media posts of a public figure, no. But I think just for the argument, I believe that there should be. This isn't a situation where my client.
Case law, counsel, respectfully. There's lots of case law.
And then Miss Budnick, I understand.
There's the Crucial matter and
Miss Budnick, I read the cases. Then Miss Fonseca, so it doesn't come in, right?
He's such an idiot. Oh my God. Sorry, the judge. This is being excluded as irrelevant to what is being sought here. Number 35 does not come in. Exhibit 35 is not received into evidence. The judge, okay.
Then Miss Budnick, 36.
Ms. Fonseca.
Then Miss Fonseca, the chicken wing one, sure.
Chicken wing?
Then Miss Fonseca, she was eating chicken wings on camera. That's another one with the messy transcript.
So confused why Ding Dong can't live with his mommy. So what the fuck is the issue? Is this anything other than defamation?
Then Miss Budnick, she calls him a dumbass bitch and a ding dong. Again, I don't think that that's defamation. I think that's harassment.
Under what case are you?
And Miss Budnick, under the definition of harassment, it's, I believe, and I'm doing this just off of memory, but I believe harassment is a course of conduct that is intended to annoy somebody, right? And so calling someone a ding dong repeatedly, calling someone too gay repeatedly, calling someone dumbass bitch, that is a course of conduct that is an annoying course of conduct that constitutes harassment.
The judge. Well, she doesn't object, so it comes in. Exhibit 36 is admitted into evidence.
And then Miss Budnick, 37. And then Miss Fonseca, no, relevance. This is the essay one. And kind of similar to the two gay stuff, when the court labeled that as defamation, especially after Dad testified it wasn't her making the allegation, it was a prior witness in the case. We didn't get to go any further into the essay stuff because, again, it was labeled as defamation, so relevance. Then Miss Budnick, my argument is the same argument I made with respect to the other ones in the sense of talking about his hair, how he looks like a girl, essays women. I think that is harassment. I think it disturbs my client's peace, regardless of whether or not it's defamatory. And then I think at the very end of the video, Brianna says, 2K, $20,000 if you can beat him in a boxing match. She's talking about encouraging someone to fight my client.
Here's the thing. The first thing, the court went into great detail about what my reading of the case law was, and I invited everybody to respond. Hold on. Let me finish. And we all briefed it. And there's cases. There's the Maldonado case. There's the Crucio. It's that
And then Miss Fonseca, Candonati, something like that.
the judge. No, it was Crucio. To me, that's the one that is most, because in that case it was two, celebrities. He was a comedian. There was a Facebook post specifically about basically accusing the other partner of SA. And there's all this case law about defamation and the First Amendment and prior restraint. And because of that, and because of everybody, whether you disagree with me, nobody provided me case law to say differently. And so Miss F strategically, because she said she had there was one video showing of Mr. Gacy saying some really awful things about Miss Olson's private area, that could also be deemed as defamation. And Miss Fonseca specifically said, I'm not going into all of that because of the court's ruling, number one. Number two, Ms. Fonseca attempted to try and show that the allegations, either that or wait, let me read that again. Number two, Ms. Fonseca attempted to try and show that the allegation that she alleged that Mr. Gacy was gay was not in fact false and therefore couldn't be defamatory. And in any effort to try and refer to his OF account, I think to show that he indeed may be gay, bisexual, I don't know. And I stopped that completely because I said the only part that may be relevant to this in the defamation case, when truth is an affirmative defense. So they made a strategic decision not to introduce that. I'm going to be very frank. I'm not going to rule on this case based on alleged defamatory statements because both of them have said horrible things about each other online multiple times. You will not win if that is your only basis upon which you are seeking. Hold on, let me finish, please. It looks like you want to stop the court. You will not win. That is not with these two, because this is not a situation where one side says many defamatory things allegedly and the other side says nothing. They are both equally guilty of that. And I've tried to tell everyone, and I want to be clear, threats are really relevant to this court because that's the exception. Even in the criminal arena, when words are not protected, when words are used for criminal action, for either threats or things like that, that's not that can very well be an exception. But if you're using and relying on all the alleged defamatory statements that she's allegedly said to him, my sense is that Miss Fonseca is going to ask to reopen all the evidence and bring in all the other statements that I'm sure are there based on a few that I've seen where your client also says defamatory statements, allegedly. So I just think your focus, and if I can focus you, anyways, should be on. And I say that a couple days ago, I heard a lot of stuff that was not relevant. I heard a few, but I would focus on those.
And then Ms. Budnick. So my purpose is really to make my objection on the record so that it's clear why I'm believing that these exhibits are relevant. I would agree that there's more here that could have been presented that wasn't in terms of statements and name calling and that type of thing.
I will on this particular one. On number 37, it will come in over Ms. Fonseca's objection, but only. I believe it's relevant, or sort of the last, starting where she says, like boxing. I'll give him 20K if he beats me. Okay. 20K if you can beat him in a boxing match, that would be where it's relevant. So Exhibit 37 is admitted into evidence.
And then Ms. Budnick. Okay, my next one is 38.
Okay.
And then Miss Fonseca, no, that's another two gay one. And then Miss Budnick, and I guess for the sake of having to repeat myself over and over, I can let the court know I have the same position as I've had with respect to 37 and 35 and the other exhibits that were objected to on those grounds.
Let me ask a question. Did you have or do you have any other potentially defamatory videos
And Miss Fonseca, yes.
that Mr. Giese said about your client?
And Miss Fonseca, yes, we had additional information from his Twitter account and OF regarding him baiting gay men and going live about how they're his biggest subscribers.
No, that's not my question. That is not my question. Do you have alleged videos or statements of Mr. Giese saying potentially defamatory things of your client that you did not offer in because of the court's ruling?
Miss Fonseca, yes, and that and that was because of the court's ruling on the two gay and the essay stuff.
So that's the thing. We have all of this, and I know the court was being harsh at the time, but nobody gave me case law to say differently, so it's not fair. It's really not fair to them to then say, well, I still want to get it in after the court's ruling when they, we're at 3:30, 2:30 on the last day of trial. My sense is Ms. Fonseca is going to seek to reopen evidence in if that's the case.
Then Miss Budnick. So my response to that would be the purpose of this, given the guidance the court has given us throughout this trial, would be that these posts are posts that disturb my client's peace. My client is the one seeking the restraining order. Miss Olson is not. The fact that there have been posts allegedly where he may have said something about her, we have no time period, nothing. That does not negate the fact that his peace has been disturbed by her conduct. If her peace were disturbed, she could seek a restraining order. She hasn't.
Okay. What I would ask you to do then at the break is tell me why all of those cases in the restraining order context specifically has specifically said that defamation is not the basis of a restraining order because you have an opportunity to seek civil redress in a civil court and all of that. And if I stand corrected, then I'm wrong.
Then Miss Budnick. So, I mean, one case, for example, just off right now would be Paris J versus Christopher U.
Yes.
And Miss Budnick, it's a Court of Appeal case for the 2nd District.
Very familiar.
Then Miss Budnick, okay, perfect. So among the content in that case, which the basis for assurance of the restraining order was a disturbance of the peace, there was context, text messages containing obscene language.
Okay, I'm going to stop you here. A text message is a direct contact between somebody and somebody else. That's harassment. That's the direct contact. Public postings are First Amendment. You're bringing things into a public arena. They're First Amendment figures. They're public figures, so a text message is different. Something is defamatory if it's published. It's put out to the public. To say something to somebody else privately may very well not be defamatory. So a text message and a public defamation are two different things.
Then Miss Budnick, well, conduct that is Family Code 6320C defines disturbing the peace, for example, and that can be conduct that's communicated directly or indirectly. And so, if the language, as in the Christopher case that I just cited, is this vulgar, upsetting language, and it's communicated indirectly, it can still constitute conduct that disturbs the peace of the other party based on how disturbing the peace is defined at Family Code Section 6320C. Because it says conduct committed directly or indirectly, including through the use of a third party, by any method or through any means, including but not limited to online accounts. And my read on the Crucio versus Pell's case is in addition to the fact that it is a single post, whereas here we have a series of posts. It was private, and so the court wasn't disturbed to anyone. Here we have many posts that are being publicly distributed. That makes them more upsetting. And then Ms. Fonseca, that's the case that you kind of implicitly ask us to bring to your attention for a separate reason. That's the case that's defined the it's not an objective reasonable, oh my goodness. It's not an objective reasonable person standard. It is the specific mental calm of the party filing the DVRO. And like the court said, as to the threats and actions taken in the case, they were of the traditional type, threatening to sue to recover money from either wedding, from their wedding, sending threatening and lewd emails and text messages, threatening to throw out belongings after they separated, requiring police intervention. So again, this is a case involving public figures and other people clipping what each of them are saying online and posting it, which neither of them have control over what's getting clipped, what's getting posted, and what the algorithm on these platforms put in front of them. So because our trial brief was very clear in line with the court's perspective on all of this, that this was a defamation case tied up in a bow as a DVRO. We are not here for a defamation case. So again, like the court said, based on the ruling as the 2-gay stuff, as to the SA stuff, We didn't present any of our additional clips or testimony about that because the court already made a ruling. So I thought if the court made a ruling on the evidence, yes, I know we're going through the list of what to admit or not, but the court already made the ruling that this is not a defamation case. Those are defamation matters, so none of this stuff should come in, especially because we were not allowed to continue to put forth our evidence on cross on these topics.
The judge, do you believe the fact in Paris versus Christopher are similar to the facts in this case, Miss Budnick?
Then Miss Budnick, I don't think they're exactly the same. I think there are definite distinctions in terms of just the type of conduct. I agree, but I think the principle and the holding in what is relevant, and I don't think that the conduct in this case is innocuous.
No one ever said it was innocuous. That's a different story. So let me read you the specific facts in Paris, and this is why I think they are different. Unlike in this case, there's no evidence presented during this case. Whoa, calm down, Tiger. Sorry, my thing just starts going up. Okay, unlike in this case, there is no evidence presented during this case of any direct communication between Ms. Olson and Mr. Giese other than in those talking parent messages, which on both parties' part were very respectful, professional, respectful. I filed the pleadings. Here it is. Thank you. Meet you there. There is no curse words. There is no too gay. There's nothing. They're very respectful. Here are the facts in the Paris case. In 2019, the parties got into multiple disagreements, which led them to engage in heated arguments via text message for several weeks. We have a situation where he said on the stand he blocked her. In his message to Paris, his direct messages to her, Christopher repeatedly insulted her, berated her, and deemed her. That's harassment. That is a direct message to her via text message to her text. He accused her of cheating on him numerous times. On several occasions, he told her he was kicking her out of the home, among other things. He stated he was going to change the locks, that he would not let her back into the home, etc., etc., etc. Then he said he also threatened her via text message directly to her and email to her and told her that he would burn and donate all the things that he had sent to her. That is so different than the case we have because the only direct communication and contact between these parties that are presented to this court are very polite and very professional. So I respectfully disagree with you that Paris versus Christopher supports that conclusion. And in fact, I think the seminal issues in Paris, or what the court was dealing with, was when talking about the emotional calm, about how that is different than sword of the criminal, what they call, well, when they talked about whether it was a reasonable person standard. The issue in that case was the person actually disturbed. But this, I don't believe anywhere in here that the word defamation ever appears.
Then Miss Budnick, and I don't know why we keep using the word defamation. We are not complaining about defamation. We are complaining about harassing communications that are communicated indirectly to my client. Conduct that is communicated indirectly to my client that disturbs his peace. Threats to my client that are communicated to him indirectly. We are not talking about defamation. We have not asked for a restraining order on the basis of defamation. That is a word that counsel keeps bringing up.
Yeah.
That is not the basis for the restraining order request.
Okay, number 36 is.
And then Miss Budnick, 38.
I'm sorry. Well, here's the thing. I think the basis of the objection is relevancy. I think to the extent it's part of this ongoing pattern, I think the court can find it relevant. So number 38 is admitted into evidence. Quick statement here, really quick. Again, when we were reading through this the first time, I didn't really catch on to all of this. I think, like I said, we were just kind of reading, right? I don't understand. I don't know if Bree's attorney keeps bringing up the defamation stuff to sidetrack. I have no idea why they keep talking about defamation. Ms. Budden keeps bringing it back to this has nothing to do with defamation. This is harassment. It is all harassment. Why are we wasting our time talking about defamation? But both Bree's attorney and the judge keep talking about defamation. It's not defamation. Now, granted, the statements that she's making can be defamatory, yes, but she's not pushing for that. So I'm so confused on why, we're on page 43, and I feel like 42 pages have been arguing about defamatory statements. Because what John's attorney is showing is defamatory. Well, it is, yes. What they're saying can be defamatory, but she's not using it as a defamatory statement. She's stating it's harassment. Can be defamatory, but they're not filing on based off of that. So it's very confusing to me. Okay, so let's continue on so we can. This will definitely have to be done in 2 because we're only on page 43 and it's 113 pages. Okay, principal. Okay, whether that's the basis, I will tell you this: those text messages of her, those messages alone, her calling him Tuge, would not be the basis upon which this court would grant a restraining order.
Then Miss Budnick, yeah, I would agree. I think granting a restraining order off of one indirect contact would be to Crucio and Pels getting a restraining order granted.
Okay, next.
Then Miss Budnick, Exhibit 40.
Miss Fonseca.
And Miss Fonseca, I mean, it's kind of the same thing.
So the objection is?
And Miss Fonseca, relevance, yeah.
Okay, well, that's overruled, but the court will indicate that the basis of this ruling is, again, the basis of my ruling, especially since your client specifically testified that the reason why she made the only alleged defamatory posting that Miss Fonseca introduced was one where he talked about her private parts in a not very flattering way. And your client said on the stand the reason why he did that was basically in retaliation for this text message. So it is relevant because it came in so. So number 40 is admitted into evidence.
And then Miss Budnick, Exhibit 43.
No text message, I'm sorry, posting.
Then Miss Budnick, yes.
Any objection, Miss Fonseca?
Miss Fonseca, no.
Okay, that comes in. 43 is admitted into evidence.
And then Miss Budnick, 46. Then Miss Fonseca. I think these are the two that I thought were the same.
46 and what?
Then Miss Fonseca. I don't know which one is 46. Oh yeah, so 43 and 46 are the ones that I pointed out when they were originally shown that I thought they were the same clip. She was wearing the sunglasses, talking to the chat and talking about kidnapping. But I think counsel says that they're different, but they look like they were the same.
They're different words.
Then Miss Fonseca. So they must have just been from the same stream. Then that's fine.
Okay, so 43 and 46 come in. Exhibit 46 is admitted into evidence.
And then Miss Budnick, 56.
Now 56? Okay, I don't think which one is 56, please?
Then Miss Budnick, it's the one where she says, "No, bitch, you're trying to fuck with me and my kid, and I'll fuck you up, bitch. Whoever's listening, play this. I will burn your fucking city down."
Yes.
Then Miss Fonseca, yeah, that's fine.
Okay, that comes in. 56 is admitted into evidence. Yikes.
Then Miss Budnick, Exhibit 57.
Miss Fonska.
Then Miss Fonseca, this is another one like some of those other third party ones, and I don't know what the third party exception is under our joint statement.
Well, again, all of these. The only thing the court is admitted into evidence is the statements that Miss Olson, unless otherwise. So you're specifically looking, Miss Budnick, on the statement. But then they're going to know I'm in LA.
Then Miss Budnick, correct. And visibly we saw the clip. We watched it. We saw her with W in a,
What's the
and then Miss Fonseca, the relevance.
yeah, what's the relevance to this?
Then Miss Budnick, so it goes, it ties into Exhibit 79, where she talked about wanting to go to LA without telling my client because she knew it would upset him.
Okay.
Then Miss Fonseca, I would still say relevance because she's never denied that she was in LA. So a clip of her telling someone else she's in LA, I don't understand the relevance to the actual restraining order.
Okay. Whereas I give Miss Budnick a little bit of a hard time about the defamation, whether there's a case law that concerns, whoa, calm down, concerns disturbing I think intentionally withholding child and bragging about it.
Miss Budnick, yeah.
Could potentially be the basis of disturbing the peace, so that's overruled. Exhibit 57 is admitted into evidence.
Then Miss Budnick, 66.
So 57 is relevant to which one, too?
Then Miss Budnick, I said it relates to all of the comments about kidnapping that she made, and then the basis for why she actually removed the child from the state.
Okay.
Then Miss Fonseca, what's the next one? Then Miss Budnick, 66. Then Miss Fonseca, I don't know which one that is. Then Miss Budnick, she says, I'm going to kidnap him from the supervised visits in Dallas. Then Miss Fonseca, oh, sure.
Okay, that comes in. Exhibit 66 is admitted into evidence.
Then Miss Budnick, 64. And this, let me be clear, 64A. Then Miss Fonseca, no, 64 is the 3-part. And we need the actual timestamps that were used because I will note as they were playing some of the timestamps in here, they're not exactly the timestamps that I was given last night or this morning. So 64A through C is that I need the 2+ hours of stream.
Isn't 64A the one page?
Miss Budnick, it is a 1-page and there is a timestamp where the statement from Brianna, the statements are shown. I did send counsel the timestamps as we acknowledged when we got here this morning, and I said these were the ranges approximately of what I'm using. We had a whole conversation about the transcripts, and with respect to all of the 64s, Miss Olson testified that these were her live streams. She made the statements. I don't know what else we need to do to authenticate it.
Okay, here's the thing. Transcripts are required under the rules of the court as an aid to the parties as they're going through the videos, but the transcripts aren't admitted.
Then Miss Budnick, correct.
The videos are admitted. The citations are, I think, as an aid and a guidance and a courtesy for lack of a better term, to Miss Fonseca. The fact that a timestamp may or may not be completely accurate does not prevent the video itself from coming in because Ms. Fonseca was provided the video, I think, some time ago, correct?
Then Miss Budnick, August 12th. Then Miss Fonseca, without timestamps. So, like I said, I didn't charge her to watch over 2 hours of footage because
Ms. Fonseca, respectfully, that's not an objection.
Then Miss Fonseca, I know, I'm just restating what I said the other day.
But you don't need to restate it because it's not an objection. That is a strategic litigation tactic, but that doesn't make it inadmissible. Go ahead.
Then Miss Budnick, so 64A is the first of these parts. I have 64A through C.
Okay, objection other than the timestamp issue, Ms. Fonseca?
Then Miss Fonseca, if this is the water gun one, then yeah, that's fine.
Okay, 64A admitted into evidence.
Then
Make
Miss
sure to
Budnick,
say pew.
oh yeah, sorry.
No, you're good.
I remember and then I'm reading and it just comes out.
I know that it's hard when you're reading.
And then Miss Budnick, and then I have 64B. We also talk about the water pew. I only used page 4 for everybody's reference.
Ms. Fonseca?
And Miss Fonseca, if we're just talking about page 4 with the water pew, sure. Then Miss Budnick, well, I mean, to be clear, I laid the whole page. She talks about blocking the street, yells, "Bitch, you're ugly," tries to zoom in.
These are all things I find relevant as to that page. Blocking the street in reference to the water, so that can come in. Exhibit 64B is admitted into evidence.
Then Miss Budnick, next is 64C. She talks again about a water pew and asks if it's assault. Then Miss Fonseca, that's not the part that was played. Then Miss Budnick, yes it was.
Yeah, I remember assault.
Then Miss Fonseca, you said you do or don't.
I do.
Then Miss Budnick, and then I played a second part on page 5 where she talks about she yells that he's an abusive man who stalks her in reference to my client.
Well, there we go. I mean, it all goes back to this alleged defamation. The part I see relevant is as it relates to the first page where she says, talking about kidnapping, not so much. They know I'm here, something. Guys, bring the water pews. Is this assault? I'll let you argue whether she means it or not, but that page is relevant.
Then Miss Budnick, okay, I have the next is.
Wait, hold on a second. I mean, I think, did you want to play the whole thing?
Then Miss Budnick, I played the second section too. So in the back of 4 into 5, about coming down to get the papers, it showed her interaction with the officers. Then Miss Fonseca, she just said that she played the first page, which was the part about the assault with a DW. So was that the first or 4 or 5? Then Miss Budnick, I played 2 sections of this recording.
Was this the one where she is walking down the stairs with?
And then Miss Budnick, no, this was when she was outside and the officers come up holding papers and she was asking them if she needed to come down and they said they were trying to serve. This is actually to Miss Fonseca's point. This is actually the recording on page 5 where they reference music. And this is how she got in the video about the song. Then Miss Fonseca, I wasn't questioning page 5, I was questioning page 1. Then Miss Budnick, Oh, page 1 I definitely played. Then Miss Fonseca, the court already said you remember page 1. So, of course, I'll take the court's.
Okay. 64C, page 1 and page 5. 64C is admitted into evidence.
Then Miss Budnick, okay, 64D. I played another section on, I believe it starts on page 6, and it again was a reference to spray him with the water pew. And then I think I went down. I played through this recording. There was a section about get his license plate in it. And then she says at the end, should I fight John right now? Will I get arrested?
Okay, where's that 64?
Then Miss Budnick, it starts on page 1. I started it on page 6 and then to page 8.
And
Then Miss Fonseca, I would say Water Pew is fine. Swagboy Q's car up there, relevant?
wait, so we start at, I'm at 60. I think I'm at 64D. The one that's like 9 pages, right?
Then Miss Budnick, right. And I started at the end of 6 or midway through 6.
So I'm not spending time with his son.
Then Miss Fonseca, in the past page 6, I don't think this stuff was played. Then Miss Budnick, I definitely played through the end because the last 3 lines she says, should I fight John right now? Will I get arrested?
That I read. So I think from page 8, where she says, should I fight John right now? Will I get arrested? Will I get arrested? That I have notes on. That came in. That is, well, Exhibit 64D is admitted into evidence. Really quick here. So what we're gonna do, guys, is we're gonna go until 8 o'clock. So like another 15 minutes, and then we'll finish up tomorrow. Because if not, we're just gonna have it's gonna be like last time when we tried to do it all in one day, and then it's just gonna be brain mush because we're getting ready to get into some good stuff. No, I know, but I don't want to hold you guys here for too long. And we're only on page 52, and there's 113 pages. So we'll see. We'll just keep going then and see that you guys are interested. Okay, go ahead. Sorry.
And then this is Miss Budnick. Okay, the next video is labeled 64E, and this portion I played. It was on page 6 where she says, I'm going to go to the courthouse tomorrow and file that he has to take a DNA test, and he cannot get W then because I don't want to send my son to a stranger.
Okay, so that goes back to that language in Curcio versus Pels. In Curcio, I think it was Curcio because I highlighted it where they talk about when they talk about the language about the DVRO is not for every dispute. Custody dispute, yes. Okay. They talk about the guardrails and the need for guardrails in a DV, Domestic Violence Acts, and it says courts are concluding that the DVPA was not enacted to address all disputes between formal couples or to create an alternative forum for resolution of every dispute between such individuals. So that's Crucio 47 cal.app.fifth at page 13. And so, and in fact, go back to your earlier point about saying that the Paris case was irrelevant, they actually, Crucio cited that the McCartney case talked about the definition of disturbing the peace and talked about how Crucio, or in Crucio, it said, it concluded that the ex-girlfriend's single private Facebook post, and I know you said it's not single, there's multiple,
Miss Budnick, right.
accusing petitioner of A being her is a far cry from the conduct described in McCartney and Evil Scissor and Burquette. And then they spell it out. Beyond that, the single post, there is no evidence that the ex-girlfriend sent the petitioner harassing, threatening, or unwanted texts or emails. That's the harassment, the direct conduct with one with one to the other, and there's no evidence that the ex-girlfriend, and this is the other thing we talked about. There was a little bit of reference to doxing. If there had been doxing, maybe. I don't know if maybe. Thank you, Missy. Maybe, but there was not a lot. In fact, he asked about GTA publishing the address, and we didn't get very far. But they even distinguished that there was no evidence that the ex-girlfriend sent the petitioner harassing, threatening, or unwanted texts or emails as in Burquette. Again, direct contact, sending something to somebody else directly, and there was no evidence that the ex-girlfriend published or distributed to third parties, the petitioners, and this is key, private information. There is nothing about these parties that's private. That's not true. And the issue is Evil Scissor was that the ex-husband, ex-partner, went in and basically improperly downloaded private messages off a computer and distributed those to somebody else. These are public figures, so that's the difference. And it said, although the petitioner was upset by the social media post for fear of her career, and that's a defamation lawsuit, and we talked about that, the court concluded it cannot set to rise to the level of destruction of petitioner's emotional conduct. Why do I have to say all that? I just think they're different. I really do, because these are public figures. They both make their lives on the internet. They both say nasty things about each other on the internet. So for that to serve as a basis of the DVRO, again, I have said my piece. Really quick, I want to stop right there for a second. I get so confused when we talk about this because, listen, calm down, Tiger. 2K is not perfect, right? Nobody's perfect. But when you look at the amount of negative stuff that 2K has said about Bree compared to what Bree and her posse has said about you, it is non-comparative. 2K has said more stuff defending Bree than what he has ever said negatively. Now, I don't know what he said about her lady bits. Maybe it looked like a wizard sleeve or roast beef. Shit, I don't know. I don't know what he said. I missed that part. But so far, that's the only thing that we're at page 55. That is the only negative comment thus far that has been brought up, that he said some not so nice things about her lady bits. But every single day, something negative comes out of Bree's mouth in regards to 2K. So I don't understand how they're trying to play it as a equal part here. You know what I'm saying? That makes any sense to me.
It makes a lot of sense, because it's also hard as like a human being not to defend yourself.
Yeah. At some time and point, you're going to defend yourself. Crazy. And really fast, if I could ask, if you guys have not yet, if you guys could please hit do your daily heart me. If we could get to 400 today, I would be so happy. We don't have to, but if we could, that would be great. I don't know what they do, but everyone keeps telling me it's important. Okay, love.
Is it my turn?
Yep.
Okay, Miss Budnick. The specific relevance to this section would be the statement that he cannot get W until then. This was made while the police were there, and my client was waiting at the house trying to receive his son for 2 hours. She's now making a statement she's not going to release him until tomorrow, at least.
So you're saying that disturbs the. Sorry. So you're saying that disturbs. Yes, bitch, that disturbs the peace. See, this is why I can only read for so long, because then I get irritated and then I want to snap back instead of just being good and reading the message. How would that not disturb the peace? The child is being held up in a house with a bunch of people that are and have pews and different stuff around and think it's a game, and the child is sitting up on the pillow with all of these cameras at him, and TTS yelling negative, sometimes comments to this child, and he wants his child back. Yeah, that would disturb my peace, Your Honor. That would disturb it did disturb my peace, and I don't even know the child. I don't know John, I don't know Brie, I don't know nobody. And it disturbed my peace. What the heck? Yeah, I would have lost my shit. Okay, sorry. Sorry, Bailey. Didn't mean to side rail. I got excited for a second. Go ahead, sorry.
No, you're good. I think it's because we're good mothers.
Right.
We feel for other, like, if I see anything wrong going on with someone else's child, I'm gonna step in. Like, hey, can I help you? Like, I'm so sorry. You don't cry. Like,
yeah. That irritated me. Why she
yep.
Okay.
Okay, Miss Budnick. Exactly.
Current case law, despite the language in Curcio that says DVROs are not meant to resolve every.
And then Miss Budnick, well, of course they are not. Crucio involved a single post that was it was isolated to a Facebook post. This is something that's happening in real time, in real life. The parties are on the same premises. The minor child is involved. The safety is at a risk.
Okay, I understand. And you object because you don't think it's relevant?
And Miss Fonseca, yes.
Well, that comes in, and I'll let her argue that later, okay? Exhibit 64E is admitted into evidence.
And then Miss Budnick, and then I have 64F. This was that 5-minute video that we watched after W had been returned to my client.
The objection, and then we'll take a break. Let's get through all the exhibits, and then we'll take a break, okay?
And then Miss Fonseca, I guess relevance, her talking about her mental health and the police interaction. I don't know what the relevance is of any of this.
Okay, page 6 is where I find relevance. I will fucking burn cities down to see my baby. I will literally burn this council. This is relevant. This is a threat.
Miss Budnick, yes, I agree.
All the other stuff, I'm not sure. This is relevant, and this comes in. Exhibit 64F is admitted into evidence.
And Miss Budnick, 73 was the post, the recording where respondent and Santos are talking, or respondent, since we're only using her statements. Respondent says we were trolling him, and we were like, we are on our way. Oh my goodness. We are on the way. We made them go outside. And my client's testimony was that this was the day after Santos and Brianna had come to his hotel to threaten him.
Miss Fonseca?
And Miss Fonseca, relevance, not a CHRO of Santos, and I don't know if I have a transcript for that one.
I do.
Then Miss Fonseca, yeah, I do.
All right. This is very relevant because this is not just Santos. This is Miss Olsen, sort of, whether conditioning or encouraging. It leads. This is the actual support where previously there hadn't been a lot of support. But this is evidence that she either directed, condoned, or contributed to Santos showing up at Mr. Gacy's hotel. Exhibit 63 is admitted into relevance. Mind you guys, I want you guys to keep this remember this piece because the judge really goes in detail about this piece right here. This section right here, and I will read it again. Basically, is the entire out of everything. This scene right here was basically the reason why they got the DVRO, and a huge reason as to why Santos is not around. So I'll read it one more time. All right, this is very relevant because this is not just Santos. This is Miss Olson, sort of, whether condoning or encouraging. It leads. This is the actual support where previously there hadn't been a lot of support. But this is evidence that she either directed, condoned, or contributed to Santos showing up at Mr. Giesi's hotel. So,
And then Miss Budnick, thank you. 74 was the actual footage that depicted Santos at the hotel.
any objections is any objection is relevance, okay, or correct?
And Miss Fonseca, relevance, and it does not come in under the exception of third-party content. Based on her testimony and John's testimony, she wasn't there. She wasn't in the video clip. She wasn't seen in the video clip. She testified she wasn't there, so the exception again under the joint stipulation is third-party content that does not feature the other client or does not feature the party has to have some nexus between the party's direction and the content that's being shown as being harassing.
Okay, so your position is you previously agreed these types of videos would not come in.
Ms. Fonseca would not come in, but there is an exception. The exception is the nexus can be drawn between the parties directing the third party to make a threat. And so, for all the reasons that I just listed, there was no nexus drawn. Both of them admitted that Bree was not in the video. Seen in the video, heard in the video, they're at the location in the video that we saw, etc. So I don't think it would come in. I mean, normally this wouldn't come in because of hearsay. So this was our built-in exception to third-party content coming in over a regular hearsay objection. But this does not meet the standard in our joint stipulation.
So are you offering this in for the truth of Santos actually saying we are here at Sheridan Park Hotel?
Miss Budnick, no. I mean, my client testified that he recognized his hotel in the background. They appeared to be there. My client perceived this as a threat because he was at his hotel. He understood Brianna to be there that evening too. And this is related to Exhibit 73 that we just admitted, where Brianna and Santos are on social media talking about the incident. Then Miss Fonseca, he never testified that he believed that Brianna was there. Then Miss Budnick, yes.
Hold on, ladies. Hold on. There's a difference between what you agreed to and whether the court can admit something over another party's objection. In that case, the court applies the rules of evidence. Okay, so it's weird that you're doing these in the form of transcripts. What you're really doing is asking the courts to accept that clip, right? Or a video, correct, Ms. Budnick?
Then Miss Budnick, correct.
So the clip itself, to the extent that the court reviews the video and the picture and what is depicted and ignores the statements, it certainly can come in to that point because you can introduce videos. She somewhat authenticated or he authenticated it, and he said he recognized her. So it will come in for the sole purpose of the video depiction in there of Santos at the Sheridan Park Hotel. The statement that we're here at the Sheraton Park Hotel will not come in because those are hearsay. because those are hearsay. Though it is somewhat corroborated by her prior exhibit 73, but it will come in solely for what is depicted in the video. Number 74 is admitted into evidence.
Then Miss Budnick, thank you. I had exhibit 75.
Okay. Do you have a lot more? Because I do.
Miss Budnick, no. I have actually just 3 more, 75, 79, and 81.
Okay. Any objections on 75?
Then Miss Budnick, oh, and 85, the OFW messages, which I think we're in agreement with. Those have already been admitted.
I don't remember hearing 75.
Then Miss Fonseca, yeah, I don't know. Then Miss Budnick, you guys don't have it? I mean, I'm reading it.
I don't remember. I don't think we ever introduced that.
Then Miss Budnick, then we don't need to worry about it. 79. This is the one where she's talking about why she took W from Texas. Then Miss Fonseca, oh, the podcast? Sure.
Okay, comes in. Exhibit 79 is admitted into evidence.
Then Miss Budnick, 81 is Santos carrying Baby W talking about a diss track in the MILF house. Then Miss Fonseca, relevance.
How is that relevant?
Then Miss Budnick, so it was posted on live social media. It's something my client saw while the minor child was being withheld there and removed from the state. It disturbed his peace to see the child unsupervised.
Then he can bring a restraining order against Santos.
Then Miss Budnick, got it.
That does not come in. Exhibit 81 is not admitted into evidence.
Then Miss Budnick, okay, and then the only other exhibit we have is 85, the messages.
The what? The messages?
Then Miss Budnick, yes.
Any objection?
Then Miss Fonseca, no, except I'd rather use ours. I mean, I know that those won't become public, but ours is redacted as to addresses and W's health information, and theirs wasn't. Miss Budnick, the one relevance with respect to addresses is that respondent twice told my client she was staying at a Texas location.
Counsel, we beat that horse for purpose of DV.
Then Miss Budnick, yeah, then we're good.
All right, let's take a break until 3:25, whereupon an afternoon break was taken. Okay, so it's a little bit after 8 here. I know for my East Coasters, it's late. It's 11 o'clock. We are on page 61. Do you guys want a break here? And then tomorrow at 6 p.m. No, keep going. I can stay up. Let's take a quick poll. Let's take a quick poll. Hold on. Oh wait, what did I just do? Hold on. Where's the poll? Oh, here we go. Okay, red, you want me to keep going? Blue, you want me to stop? Red, keep going. Blue, we'll take a break and finish tomorrow. You guys just don't want me to have dinner. I knew it. I knew it. Okay, we'll keep going. This is a landslide.
Man.
Well, let me take a quick break. Let me go run and use the bathroom. So I'm gonna take a quick break, and then we'll come back. So Bailey, you can entertain if you want to. Just give me 1 second to use the bathroom, and then we'll keep going. Look at you guys, 148 to 5. And then don't forget your daily Harveys. We're trying to push to 400 for some random reason. Yeah, grab a snack and come on back.
Thank you for the gifts, whoever was sending those. It's hard for me to read Bree's attorney because I want to get an attitude because of the things she says. Oh, thanks. Thank you. I hate my voice, but I feel like everyone hates their own voice. Bree's attorney is Miss Fonseca. No, Bree did not get a DVRO against John. Her attorney is very annoying.
Okay, I'm back. I need like actual chopstick though. Man, we are having crazy weather. Okay.
I do think 2K should get a restraining order against Santos, but I think he should also add Baby W into it because of his obsession of
I'm
the
surprised
baby.
that hasn't been done, to be honest with you. I feel like there's a reason why. Because it just seems like that should have been done. But anyways, we have a snow.
Hey, whoever said
No,
they're in Salt Lake, I'm in Utah County.
I want snow. Ours says we're supposed to have snow in a couple days, but it's like snow mixed with rain. It's not going to be snow. We're just flooded absolutely everywhere. So I'm surprised
I
that we've held up.
saw.
I'm surprised we've actually held up. We're supposed to in the next hour or so, which is why I wanted to get some cooking on too, is have some massive winds today. And again, as you guys know, I'm surrounded by trees. We always lose power. So we'll just, oh, here comes rain again. Okay. All right. So let's just keep on reading then. Okay. So here we go. The court. All right. We are back on the record.
Then, Miss Fonseca, you want to go through your exhibits? Oh, that was your part.
Oh, sorry. Miss Fonseca, you want to go through your exhibits? What am I doing?
Then, Miss Fonseca, yes. So, Exhibit A was the redacted OFW transcript.
Any objection, Miss?
Miss Budnick, no, I have no objection.
Hold on. Give me 1 second. Whereupon there was a brief pause in the proceedings. All right. So we're back on the record. Exhibit A, the Our Family Wizard, correct?
Then, Miss Fonseca, yes.
And no objection?
Miss Budnick, no objection.
Okay. Exhibit A is admitted into evidence.
Then, Miss Fonseca, Exhibit B, the monitor reports.
Did I even see those?
Then, Miss Fonseca, no, it was on our joint statement to come in automatically, and we tabled talking about them because you said that would come during custody visitation, but I know you're making some temporary custody and visitation.
Let's table those because I want to have a separate record in case there's an appeal for the DVRO.
And then Miss Fonseca, okay.
So you can introduce those monitored reports for the custody portion.
Then Miss Fonseca, okay. L.
Was
Then Miss Fonseca, there was the TikTok comments made by Grandma that she was questioned about on the stand. Then Miss Budnick, I would just object that they're irrelevant. Then Miss Fonseca said it was threats made by Grandma after they put up testimony about alleged threats made against Grandma by my client. Then Miss Budnick said, and I would object to the characterization of the post as a threat. I believe it was a post saying she would seek grandparent visitation rights.
That's fine. I mean, none of this is helpful to me in deciding the DVRO, but that's fine.
And Miss Budnick, that's why my objection for irrelevance.
Well, I think she says, I think she's said in response. Anyways, they come in. Exhibit L is admitted into evidence.
And then Miss Fonseca, P, the pictures of bruising on Brianna's face.
Any objection?
And then Miss Budnick, yeah, I object. Those were not authenticated. They lack foundation. I think her testimony was all over the place with respect to dates, with respect to what was depicted depicted. Oh my goodness, depicted. So I would object that those come in.
Okay. Before you respond, again, I'm trying to narrow down the scope of I'm not taking anything away from Miss Olson to the extent that she alleged that she was physically AB'd by Mr. Giese. The reason why the court, as I'm thinking about it, kind of, I don't know if it was the best idea to open this, was to negate potentially because there's a representation of, well, or we'll get into the DV. It would negate that, you know. His peace was disturbed and all of that, but so I let it in. But I will say, I'm not dismissing it, but it's not particularly helpful. She alleged he slapped her in the car. Then there's a video of him playing that. It may not have been the full thing. You can't hear it that well. I will say in the original testimony, the injuries are not consistent with one slap. There's 3 separate bruises, and then she said that there was a different bruise. So I let it in because I said I'd let it in and it's consistent. Well, it's evidence in support of that testimony. I will say that testimony does not help me in any way, shape, or form in deciding this matter. So I'll let it in, but I don't know what the relevance is. That was a whole lot of words, basically to say her story doesn't make any sense. I'm going to let it in for absolutely no reason because her story doesn't make sense. She said that he slapped her one time, but she had multiple bruises. You guys, and what the part that they're talking about is the bruises that were like here around the lip, on the bridge of the nose, all the places that she stated she was getting filler. That's what she said during those times before all this came up. Later on, she then said that was the slap, right? Okay, right. Okay. So Exhibit B is admitted into evidence, Ms. Fonseca.
And then Ms. Fonseca, okay, question. Can the clerk turn the sound back on? My staff said they can't hear since we came back from break.
Or they can't hear over the very loud fan.
Ms. Fonseca, no, it's just muted.
Okay.
Then Ms. Fonseca, Exhibit AA. This is the clip and transcript of John talking about Brianna's health. Then Ms. Budnick, no, I think the court.
Well, in fairness, Ms. Budnick, you can't have it both ways.
Then Ms. Budnick, I understand.
So if all of this, brief pause in the proceedings, all right, those come in, that comes in. Exhibit AA is admitted into evidence.
Then Ms. Fonseca, CC, this was the John's Live with the transcript where he was playing a recording that he took of Brianna, which was regarding the incident that she testified about as to the DV.
Ms. Budnick?
Then Ms. Budnick, I feel like there's so many foundational and authentication issues with that recording. My client wasn't asked about it.
Yeah, that doesn't come in because of, Exhibit CC is not admitted into evidence.
Then Ms. Fonseca, HH, the live and transcript of John regarding the justice to raunchy hoes. Then Ms. Budnick, I also object to that. My client wasn't asked about it. It's not authenticated.
Wait, what is the...
Then Ms. Budnick, was he? I'm sorry, I'm thinking of a different recording.
Hold on. What is an objection that your client was not asked about? If asked about it, if they introduced it, how is that the basis of an objection?
Then Ms. Budnick, well, I guess if the purpose of it was the effect that she had when she heard it.
Just because you opted not to offer and have your client, that does not mean she can't authenticate and say, I heard it, I saw this.
Then Ms. Budnick, I understand what you're saying.
Okay, so that comes in. Exhibit HH is admitted into evidence.
Then Miss Fonseca, KK. This was the video with no transcript because it was just music of Swagboy Q's recording Swagboy Q recording John, and John smiling at the camera outside of the MILF house on the day of the March incident. Then Miss Budnick. I have no objection other than just the recording depicts my client pacing and
Okay.
then Miss Budnick. At one point he smiles.
Okay, that's not an objection. You argue what you argue what it so it comes in. Exhibit KK is admitted into evidence.
Then Miss Budnick, I understand.
Okay?
Then Miss Fonseca said, this was the video and the transcript of John and his mom and W being interviewed at Swagboy Q's house right after they got W back in LA during the March incident.
Objection.
Then Miss Budnick, it was not an interview, but I have no objection.
So I'll take that as a no. Exhibit MM is admitted into evidence.
Then Miss Budnick, correct.
In the interest of time, we either have an objection or we don't have an objection. Go ahead.
Then Miss Fonseca, RR, the video and transcript of John being live online talking about winning full custody. Then Miss Budnick, I just don't have a recollection of this exhibit. I know that it was played.
RR, the transcript. Do you know the page on that, Miss Fonseca?
And Miss Fonseca, sorry, I can't think. Sorry, I think or I can pull it up actually.
It's okay. I have it.
Then Miss Fonseca, it's 639 in the transcript. Then Miss Budnick, oh no, I don't have an objection to this.
Okay. Exhibit RR is admitted into evidence.
Then Miss Fonseca, TT, was the video and transcript of John saying, I'm gonna take this baby and give it to my mom, and you're going to have to pay her child support. Then Miss Budnick, I object to this on relevance. This was the clip that respondent testified actually was created before W was even born. And Miss Fonseca, that is not as she testified it. She testified she saw that in April. She did not testify to when it was created. It was created by John.
All right, all that comes in. And just to go back and clarify in case you guys don't know, it doesn't matter when she saw it, and it's crazy that she thinks she saw it at a certain time, but if I remember correctly, she was actually there when it was stated. They were having a conversation about co-parent and all this stuff. I think it was before baby W was even born. And she was like, I'm not gonna co-parent or something. I can't remember exactly how it happened. And he's like, oh, that's fine. I'll just take the baby, give it to mommy, and pay child support. It was all like in a joking type way. So I don't know why she said that came after all of this, but she was there when it happened.
Yeah.
Okay. So Exhibit TT is not admitted into evidence. Okay.
And the Miss Fonseca, UU, was the video and transcript of John's interview with Perez Hilton where he said, no comment, and then started laughing as to the question about DV. Then Miss Budnick, that's irrelevant.
Well, it's not. Somebody saying no comment can mean so many things. It doesn't prove anything, so relevance doesn't come in. Exhibit UU is not admitted into evidence, and I'm so glad that this wasn't admitted because a lot of people, if you guys watched when this happened, a lot of people were like, oh, he's cooked because no, it did not look good the way that it came out, right? But I was actually in the live when it happened, and a lot of people were letting John know ahead of time. Perez at the time was very new to TikTok, brand new. Like he was just starting.
Yeah.
But any of us old timers, us old Gen X, we know Perez, okay? And Perez is messy boots, I tell you. So we were already letting him know. We were letting 2K know he is messy boots. Be very cautious of what you say, right? what you say, he will twist and turn and flip right back over to Bree and so he's going to play this whole game. So be cautious of what you say. So a lot of us were already letting him know because love Prez, right? But he's messy. So Prez had just got done doing an interview with Bree, getting all this information. Then he goes live with 2K, and it's one of the first questions he asked. Oh, so I heard that you were hitting on her. What are your thoughts on DV? And 2K literally says he's like, no comment, and laughs because again we're in his chat saying don't even placate into it. He is Miss Messy Boots. But if you don't know all of that other information that's happening behind the scenes and know Perez, that could have been a very bad look on him. And so I'm really glad that they did not play that into it. And 2K got a lot of flack after that. A lot of people really came for him because they're like, well, why would you say no comment if it wasn't true, etc., etc., etc. Well, I guess we can say the same thing about Bree right now when she says that the way that she keeps Santos in line is she has to beat him at least once or twice a week in order to keep him in line. And they do the whole, playing games of the DV and black eyes and all that other stuff. So, but I did want to give context on that situation because it did look bad if you didn't know what was happening.
I'm a millennial and I remember back in the day Perez. So
Perez was here before like TMZ. Like Perez was the original OG messy boots drama. He let us know. He kept us on the haps of all the haps of all the happening. I don't know what happened, and he's messy. But honey, I'm here for it. I love the messy, but not when it comes to situations where it like this. This was not a situation to be messy. So that's why I wanted to make sure it wasn't just me. There was a lot of us in 2K's thing. I'm a silent watcher. I don't typically go in and chat on other people's lives. But that day I did. Yeah, because I wanted him to know. Don't do that. Don't play into him because he'll use it for gain.
Yep.
This is the transcript from their trial. Okay, we're going to continue on. We'll keep pushing through. I don't know how much longer I'm going to go, but because our storm is picking up, if you guys can hear. Okay, so we're in line 20, Miss Fonseca.
And then I remembered from last time. So Miss Fonseca, Triple K was the video.
You'd think they would skip that one, but okay.
Was the video and transcript of John threatening Santos and saying he gave Bree the deal of her fucking life.
That's irrelevant. Factual.
Miss Budnick, thank you. That would be my objection as well.
Not coming in.
The Miss Fonseca, so...
What? I mean, tell me what the relevance is if he's threatening Santos.
The Miss Fonseca, we let in the clips, or we let in at least one clip of the reverse of Santos allegedly threatening John.
Really fast, just to back this up, I don't understand how that's a threat with John saying, I gave Bree the deal of a fucking lifetime. He did! He did!
Yep.
He paid for everything. He stayed in LA to have the 50-50 custody. She didn't have to travel. She didn't have to pay for anything. He paid for absolutely everything. But how is that a threat? That's facts. But anyways, I'll keep reading. Right. But only in connection that I said. I was very clear when I said this is the one time where that was a connection between your client and something that a third party did. So I connected the two. To me, that is, to me, that's like the seminal clip. That was, and what she's referring to, guys, is at the hotel when Santos went to the hotel and she said that Bree orchestrated it. Okay.
And then Miss Fonseca, the hotel clip and the restaurant clip?
No. Well, I don't know if it's the restaurant clip where she's talking. She's talking and seems almost gleeful that they went to Mr. Giesi's hotel. That's where There is a connection between the two, but Mr. Santos is not seeking a restraining order here, so that does not come in. Exhibit Triple K is not admitted into evidence.
Ms. Fonseca, the video and transcript of John admitting to embarrassing Santos online and making other disparaging remarks against him. That was PPP. The Ms. Budnick, same objection.
This is not about Santos. That does not come in. Exhibit PPP is not admitted into evidence.
The Ms. Fonseca, CCCC, the 8/22/2025 Snapchat video and transcript of John advertising his Snapchat inside the courthouse. The Ms. Budnick, objection. This is irrelevant.
What is the relevance other than it was a really bad idea? It was in violation of the court order, and it may very well affect my decision.
And Ms. Fonseca, motive for filing the restraining order in the first place being for monetization and clout. The Ms. Budnick, he can't demonstrate something that was filed in March. The motive for that filing can't be demonstrated by something that happened this week. The Ms. Fonseca, it's an ongoing motive. He made repeated posts like this.
Well, look, there's, by his own mouth, he said that he earned 6 figures just from the posting regarding the police standoff, for lack of better term. I think there is sufficient evidence that he has profited monetarily from this whole proceeding, as has she. So that doesn't come in overruled. Exhibit CCCC is not admitted into evidence.
Then Miss Fonseca, HHHH, was the music video that we watched today and the transcript.
Tell me how you think that's relevant.
Then Miss Fonseca, so as to him creating this whole kidnapping narrative online, and I know you don't like that word, but that's the word that.
And I'm sorry, I misspoke. It's not that I don't like it. It's that the court never made that comment. But I understand your point, Ms. Fonseca. Your point is that he monetized off the word kidnapping, and that that was all part of your position. I'm not saying I agree that he created this narrative online that W had been kidnapped and that increased the amount he received, correct?
And Miss Fonseca, and then never corrected it after we had that conversation with the court on May 2nd. So it goes to that part, and then to he brought in the exhibit about, oh, I'm upset because Santos is allegedly making a diss track, yet he dropped a diss track about Brianna the day he filed an ex parte for alleged kidnapping, and then impeachment as well the testimony he gave. I think 2 days ago, I was disgusted that he was in this MILF house because I believe they use illicit D's in there. And he's making or posting a rap video or whatever it's called, making D references.
Okay, I'll let you respond in a second, Ms. Budnick. Here's the only potential relevance to this. There was much testimony, and I think that kind of, again, but I still disagree with Ms. Budnick's perspective, or perception, regarding whether the alleged defamatory statements can be served as a basis for his peace being disturbed. To the extent, the fact that he testified that he was upset and he was stressed, there were lots of videos about the exchange and how stressful this was. And my understanding was Miss Olson testified that she saw this video sort of in the court of law, that he doesn't look particularly upset or stressed. So it's relevant to that. But the rug thing, I don't know. It's neither here nor there. All right. Did you want to be heard anymore?
And Miss Budnick, I guess there has been no evidence whatsoever that this song was created in connection with the March incident or that the music video was filmed in connection with the March incident. My understanding of the music business is they take time to create. Music videos take time to create. The idea that this was a song that was written, published, distributed all in the same day in connection with I don't think it's sufficiently, I don't even know that word,
Attenuated to show any kind of,
attenuated
yeah.
to show any kind of connection to the incident.
The only thing is what she testified to, what she saw posted, and what she believed to be his TikTok. I think did she say the 24th?
The Miss Fonseca, the 24th was the date on the video. Yes, on his actual TikTok is where I accessed it.
So that was the day before this. All this drama. So it's irrelevant to that. It undermines potentially his credibility on that one. Exhibit HHHH is admitted into evidence. Anything else?
The Miss Fonseca, no, that was it off of our list.
All right. Do you guys want me to give you a tentative, or do you just want to argue, and then I'll hear from both?
The Miss Budnick, I think it would be helpful for me to know if the court gives a tentative, and then since we're already at 342, that would help.
Is that okay with you, Ms. Fonseca?
The Miss Fonseca, yes.
Okay, hold on. Let me take a drink so I have to read. I'm gonna sleep good tonight. You guys hear this rain? Mm-hmm. Okay. I want to make a couple perfunctory comments. That's a funny word. The case I also went back and looked at was Evans versus Evans 126. That's another case. I think it's a DVRO.
The Miss Budnick, I know, I read that. I just can't. I feel like I referenced that in the brief.
Right. So this is a case where it was a former DVRO, but he basically sued his former wife, alleging cause of action including harassment, defamation, and breach of privacy. And one of the things that he sought to enjoin her from was publishing false and defamatory statements about him on the internet, publishing confidential personal information, etc., etc., etc. And again, I think that case talked a lot about defamation and how you enjoin it. And the reason why I say all of this is the purpose of the DV restraining order is to protect the peace and give them some peace and to give them some distance from each other so that they can, because what you're doing is an injunction. You're telling someone don't do X. And historically, it would have been in the context of don't commit physical violence against somebody. And we're enjoining you from harassing, disturbing the peace, etc. Because the idea is that the conduct that had occurred previously, which rose to the level of DV, needs to be enjoined or stopped for the parties to have peace. There have been no colorable evidence that Miss Olson committed physical violence against Mr. Giese. The large bulk of the evidence that I saw produced was in the vein of alleged defamatory statements. And so, in essence, me saying to someone, don't use physical violence against anyone if I issued that order, it would be meaningless because there was no evidence that she did that, has done it before, or will do it again. In terms of the sort of harassment, let's destroy peace. Well, let's talk about harass. Most of those cases we talked about that I reviewed, and we've all talked about them, were cases where there was direct contact by one party to another, calling, texting, email, etc. And in those cases, the court said that in sort of this harassment pattern or conduct. Or we have a case like Evil Scissor, whatever his name is, where you have a private figure whose private and sensitive information was improperly accessed by one of the parties and was revealed to the other, to like family members or things like that, and made more public. None of which is the case here. What we have is public postings by a public figure, as public as can be on traditional First Amendments about another public figure. And that's where the First Amendment is aesthetic. When you're asking the court to, in essence, prevent words of speech, you have to be cognizant of the First Amendment and its protections, especially in a case like this. Not all speech is protected. Speech that is defamatory is not protected. But I believe the court, I believe the courts have said in Evans and others that that your remedy to that is to not enjoin it in the future because that's a prior restraint. And how do you do that? And the courts have said, the only time you do that is when the speech has already been determined to be defamatory. And I'm not going to decide because this is not a defamation case. And related to that is when someone successfully sues for defamation. One of those remedies, one of the damages is emotional distress. That kind of stuff that they're talking about. That's why you bring a defamation case. You said false statements to me on the internet. They were false. You did those with reckless disregard for the truth because I am a public figure. I suffered emotional damage, distress. Those are my damages. That's not what we're asking here. You're asking me to basically enjoin future conduct, enjoin basically similar conduct, and it'd be interesting to know exactly what you're seeking to have enjoined. I heard some initially reference to maybe she revealed naked eggs and bakey pictures to someone. Sorry. That might be because that's revenge porn, potentially. I heard no further evidence of it. I heard a little bit, and I heard nothing after. I didn't hear when. I didn't hear by whom. I didn't hear how. I heard nothing more of that. And in fact, I also heard again, no disrespect to either party that may have had an OF account in which he may have engaged in sexual acts on the internet. I'm not bad-mouthing him for that. I'm not criticizing him for that. I'm not, that is also a First Amendment expression, but that might have been had there been more evidence that had occurred. That could have been the basis of the DVRO. I didn't hear enough to meet the preponderance of the evidence standard. What I did hear, and where I do believe the courts have said the First Amendment and the First Amendment has a limit, is threats. Because there is all this case law that talks about, and there is a different kind of criminal acts that are based solely on threats. There's, let's just look at the penal code in California. Fighting words or direct. That has to be direct to a person. You say to a person, I'm going to kick your ass, whatever it is. But there can also be a lot of certain criminal threats. I'm going to you. I'm going to do this. I'm going to put you in fear for your safety. All of those, the courts have said, are not protected. And in fact, if you look at it, sort of, the categories, it's interesting. Because if you look at the categories of what can be the basis of a DVRO in this case, we don't have the first couple, which is sexual assault, physical, fear of imminent physical harm, those kind of things. What we're really all talking about is you say harassment, but respectfully, and I know you guys will all research this to the hills. I have not been given a case which defines harassment in this context that we have seen where someone someone clearly does not directly make those comments to someone else or call them or email them. But somebody posts something on something. Sorry. Thank God I did. My phone's about to die. Hold on. Gotta plug my phone in. There's a whole lot of. Thank you so much, Brandy. I so appreciate that, you guys. You guys just keep tapping if you haven't sent your daily heart me's. Katie, we're reading the transcript from Bree and 2K's trial. Okay. I don't even know if she said sort of, I knew that he would see it. I don't think we ever made that connection per se, but where? Because he said he blocked her. But you? I have not been given a case that said in this context her public posting is something that he may or may not see as harassment. So what I'm left with, and where I do think actually there is sufficient evidence, is these threats. And there were threats. There were several threats. And those, I think, and that's why I tried to telegraph everybody in the beginning, but everybody just kept doing their own thing, and that's okay. But there were several of those, both to his mother, but most importantly directed to Mr. Giese. And I'll go through those. Let's see. This is where it's going to get interesting. Look, I think the most clear one is the thing involving the hotel, because that's the only time, there was a lot of testimony in the beginning about what Santos did or did not do. My sense is Santos is listening only to Santos. This court had made some orders, I think, of not filming and understanding who's filming. There were a lot of times where he was sort of doing it on his own. Mr. Giese provided testimony that he and Santos had beef. And so my sense is Santos did what Santos wanted to do on his own. Where I think that changed was the incident with the hotel, because there was testimony, and Mr. Giese specifically said, I was at that hotel. They knew where I was. There's a video of them at the hotel. Mr. Giese said, I recognize the hotel in the background. And I'm going to get into the statements that Santos said, because I'm not going to get into the statement that Santos said because I don't need to. There's the hotel. Mr. Giese identified the hotel. That's Exhibit 74. Then we have Exhibit 73, and that's Miss Olson's own words. And she said, and so when she said, and so then we were trolling him and she said, we. She may not have been in the video, but in this statement, she puts herself there. She said, we were like, yeah, we're on the way. And then she made them go outside because we're like, we're outside. And Chris, what did he do? He got up and he knocked, he got up and he knocked on all the doors of the hotel. That telegraphs me, she was there. She saw what happened because I guess they're all staying next to each other. And then I guess this is Santos says, bro, he was scared. He had to get out. And Brianna is like, come out, guys. We're going outside. And so then she was saying we, because that's important. She doesn't say they, she says we. And so then we made them go outside and they were looking around and they're so dumb. And then she says, and then we posted the video of him fighting, it just says MA, so I don't know, fighting Ma, MA, I don't know if MA stands for something, I don't know what that means, on our Twitter. I don't know. So if y'all want to go see it, we posted the video, and yeah, wait, run my flowers. So that's troubling. So that's not really words, that's actions. So that, I think, even more so takes us out of the First Amendment. And so I have that because she's also, she's also there where statements were okay. Look at Exhibit 34, March 16th. Prior to this incident with the police, where my baby at? Dead ass. Bring me my baby. Bring me my baby. I'm going to fuck you up. I'm going to fuck you and your mom up. Not just the mom, him. Dead ass. Fuck you and your fat ass mama. I'm going to fuck up, tap, 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 tap. Sorry, I forgot I was on TikTok for a second. I was just reading. We love the TikTok shop. Do all your little things. Sorry. I was just reading. Forgot where I was for a minute. I'm going to F you all up. That's a threat. Let's see. 43. Yeah. We should just go kidnap our kids. Yeah. Yes. All right. Fuck it. F it. Sorry, TikTok. Shit. That's the plan. Count on it. Why? Do you think she's going to clock me? Oh. That's good to say before court. It's a joke. We ride at dawn. I see that as a threat, sort of combined with everything else. There were more. 56. I think Mr. Gacy testified that he saw her around March 23rd. Brianna, no, bitch. You're trying to fuck with me and my kid, and I'll fuck you up. Jesus, criminy, I'll F you up. It is so hard when you're reading and you're just going with the flow. You're just used to reading. You gotta try to switch stuff up. Sorry, TikTok. Love you. Just tap, 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 tap. Whoever's listening to this, play this shit. Whenever you want to play this shit, bitch. I will burn your effing city down, bitch. You're not going to keep me away from my child. How'd that work out for you?
Right?
Imagine saying all of this, and she's not even done. The judge is on a roll right here, okay? That's why it always cracks me up, and everyone thinks that the judge is so pro-Bree, because I think they haven't heard all of this stuff, you know? Thank you, Brandy. But imagine saying all of this while you're in the midst of court. Anyways.
Right after your baby just got taken from the
literally
by the police.
You will go down, you will go down your effing city. That ass bitch, I'm actually effing insane. If you want to see it, you can see it. I don't care. And then she says, well, she testified. She said, I wasn't talking about John Gacy genuinely. I may have to expedite. I may have to hurry this up. I think a tree just fell. I heard it. Let me see. She testified. She said, "Oh, I wasn't talking about it in January." Like the judges just be like, "Oh, all that other stuff." She said, "I was just kidding. I wasn't genuine." You know, I don't find that credible. It was clear to me who she was talking about. I mean, there's lots about and the water pew. Look, it's a water pew. It's not. It's a water pew. I'm not taking away from it, and it's not. It seems like a joke to her. Maybe not. But she keeps talking. I love that. She keeps talking. There's multiple things with the water pew. Should we hit him with the pew? No. Save it for Jen. I mean, save it for, oops, I can't say that. The water pew is kind of neither here nor there. I think if it were if it was a water pew alone, I think it would be. But to me, it's the water pew in conjunction with all of the prior statements about burning the city down and going to his hotel. 64A, pew his mom straight in the face. She deserves it. And again, I don't care so much about the water pews, but again, I look at 64D at the bottom. Brianna, should I fight John right now? Yeah. Will I get arrested? No, don't do it. Don't do it for real. She threatened to fight him. That is relevant. That is the kind of thing that I think this court can use as a basis up for a DVRO. Not all of these sort of alleged defamatory statements. Then also 64. I think, is it F or G? Where? It's the one that's 7 pages, and I'm looking at page 6, which starts with Swag Boy, and then she says, guys, seriously, in all seriousness, I will fucking burn cities down to see my baby. I will legally burn cities down. Is she directing that to him? I don't know. But in conjunction with the other places where she does, I think it could be taken, obviously, as a threat under the preponderance of evidence of the evidence standard. So I do believe the one. I think on her going to and she puts herself there. I think her going to the hotel alone would be enough. But there are other things that I've said, the statements, the threats that I've heard. There's one more. Exhibit 3. I mean, granted, it's more towards mother, but she says, PTSD, bitch. I've got PTSD, bitch. Your mama's next. I'm pretty sure that's referencing Mr. Gacy's mom. That was too far? Cry about it, ho. No, dead ass. I'm going to say anything. Never mind. She said some horrible things about being stuck up each other. Again, that's potential defamatory. Rhonda! Could be disturbing the peace. Maybe, maybe not. Oh no, that would disturb the peace. That would disturb the peace. That's craziness to me. Then, Exhibit 75. Santos said, let me catch him outside. I know that, Santos, but Miss Olson is there. She says, he didn't say any names. And then she downplays it. No one's threatening anyone. We're not saying names. I don't think that's credible. And Santos says, I will whoop his fucking ass. Again, that cannot necessarily be attributed. That one is not as strong, but there are a number of them. And I believe those threats alone That is exactly the type of speech that is not protected under the First Amendment. It could be a basis of a domestic violence restraining order. So I would be inclined to grant one of the basis of those. Let me hear from you, Miss Fonseca.
And then Miss Fonseca. So back to the case that we talked about earlier. The one that Miss Budnick brought up about the standard. It was the disturbing the peace standard of the person that actually filed the restraining order, not of the reasonable objective standard. So, regarding when he said his peace was disturbed, I guess we should go and is this like technically a closing, or am I just responding to?
Well, you can go and make your closing. I will say one more thing on that. Thank you, love. Thank you so much. I will say one more thing on that. Mr. Gacy testified that he was scared when they came to his hotel. That I believed. That I believed. That I believed. Because she was outside with Santos and somebody else threatening to. That I found credible. And to me, that alone, and I do not believe what the case law says. It says it does not have to be reasonable. But the way I read it, is that I have to believe that he actually felt his peace was disturbed. And thank you, love. And I do believe as to that incident alone. So you can give your closing. I just wanted to telegraph what my tentative was if you wanted to address in your closing. Thank you guys so much for all the gifts. I so appreciate it.
Then Miss Fonseca. Okay. So I can go out of order. That's okay.
Sure, that's okay sure, that's okay with you, Miss.
Then Miss Budnick. I have no issue. Then Miss Fonseca. Okay. So it's a similar position that the DVRO was filed for an improper purpose, for content, for views, to continue to harass Brianna following the end of their relationship. I personally did not find he and his mom's testimony to be credible. There was a lot of conflicting testimony given between the two of them. For example, the 2K private investigator group chat that we talked, that John testified about, where he said those were clippers that give him free content. That makes my client look bad. When Grandma was called to the stand, the first topic that counsel chose to cover with her was the exact topic, and Grandma changed the entire narrative and said that was just a family group chat in good fun and had nothing to do with the case. It was actually Grandma that testified about Dad having panic attacks. In all these different instances, Dad never actually testified that he ever had panic attacks. He said he feels anxiety when random strangers flood his chat feed. And then it was Mom that testified that he threw up on the day of the alleged kidnapping incident. But his testimony, I don't even think his testimony about that himself. I don't even think he testified about that himself. As to the whole kidnapping situation, the testimony confirmed from Grandma, Brianna, and John that the exchange in Texas was done between Grandma and Brianna because John was already here. Also, the end of today kind of confirmed why John was in LA. He was dropping a music video on the same day that he filed an ex parte motion. Brianna confirmed prior to the police coming to her house the following day in her testimony that, and the Our Family Wizard messages also confirmed that John did not reach out to Brianna except for one time on the 23rd, which was the day of the custodial exchange in Texas. On the 24th, when he was in LA dropping his music video on the same day that he was filing the ex parte kidnapping motion. He did not reach out to her at all. He never called her. He never texted her. She testified that Miss Budnick never called her, never texted her. She testified on that day of the ex parte motion, the 24th, that nobody ever showed up at the MILF house to try to serve her with the order. The same thing on the morning of the 25th. She testified nobody ever came to serve her, so for her first encounter with the orders was via our family wizard that morning, which John's testimony was, I was sick to my stomach. I didn't know where my kid was. I called a single welfare check to LAPD. I filed a motion. But then we see that our family wizard conversation between them tells a completely different story. They were talking leading up to the police coming to the MILF house that day about meeting at the police station. Brianna said that was too far. He's having a nap. John said you shouldn't have taken him. So just goes again to John's credibility about him being disturbed, concerned, bothered, etc. Because they were, in fact, talking before the police even got to the MILF house that day. Brianna confirmed that she did not have a lawyer at any time during March. She did not have a lawyer on the phone as Miss Budnick had tried to say in some of those clips that we watched today. It was her managers directing her as to what to do. She confirmed that Itai and Jordan were her managers at the time. Denied Miss Budnick's question about one of them being her romantic partner, and that it was those two that were directing her what to do. And she had to listen to them because she was under their management. Sorry, I just called BS on all that because I watched it all live, but
Right. It's the same as, like, for those of you guys who weren't here in the beginning, she tried to say that on the podcast it was a script. All of that was the whole podcast was a script. So I would be very curious on that. But yeah, you're right. It's all of it just bullshit.
yeah, it gets kind of hard to read, and I'm like, ooh, Bailey,
Yeah,
just shut
it
your
does.
mouth. Okay, and then there was conflicting testimony given between Mom and John and Brianna as to where everybody was during this encounter. Just goes to credibility, again, of the witnesses and how they were actually feeling regarding this incident. John testified on the first day that he is physically and mentally affected by his mother being John testified on the first day that he is physically and mentally affected by his mother being mentally affected by this case and by the publicity, and that she has to turn off her phone because anytime something bad is said about her online, she's bothered by it. But then we have Mom or Grandma coming to the stand and confirming that on the day that the ex parte kidnapping RFR was filed, Grandma gave those documents to T Pages voluntarily online before they became part of the public record. Told the T Pages that the restraining order later that week was being filed, and her justification for this was because she was trying to get Brianna's attention. And then when asked if she was aware if John tried to reach out to Brianna at all that day, on the 24th, she said she was unsure, but multiple times he had tried. But then we see on Our Family Wizard that there was actually 0 attempts from Dad to reach out to Mom at all on the day that he dropped the music video and filed the ex parte motion. He said that his peace was disturbed when some TikToker named GTA threatened to release his address claiming that Brianna directed this. It's important to note that in Exhibit 16, which was their moving papers on the restraining order, this allegation or this set of facts was not mentioned at all, even though John's testimony in the courtroom was that he allegedly saw this clip in December of 2024. Yet we know the restraining order was filed 3 months later in March of 2025. This was his lead, most compelling testimony on the first day, that we heard his testimony on Friday, but there was nothing presented in his exhibits list. He said there was clips. We saw none of those clips. Brianna confirmed that she doesn't know this person personally, only met him once in real life in a group setting. Had no conversation with him, never directed him to say anything about her or about John online. John testified his peace was disturbed when Brianna was calling him an abuser online. He denied ever being in the car with Brianna in Florida when she was pregnant. We later saw him go live in one of those clips that we showed where he was talking about that exact incident, playing a recording from the exact incident. Brianna shared her testimony as to the physical abuse that occurred. Oh, sorry.
Hmm?
I don't know if we should say physical abuse or not.
Yeah, that's okay. I
Okay.
usually, instead of abuse, I just say AB. I say physical
Okay.
AB.
That occurred in the car when she was pregnant and shared her photos. We also saw the clip of John being interviewed by Perez Hilton about this, and he was laughing about it, saying no comment as to the allegations of DV. Said that his peace was disturbed when Brianna took W from California to Texas last November, but then Brianna confirmed through her testimony that there was no restraining order, no ex parte, no nothing done over this. So the timing of all of those exact things being done the day after the music video is dropped when John is already in LA per his own testimony is questionable at best. John said his peace was disturbed when Santos was harassing him online. Then he went into extensive testimony about how they used to have a friendly relationship and friendly online banter, but that changed when Brianna and him broke up and she started dating Santos. And he continuously claimed that he was afraid of this person while simultaneously admitting that he taunts him online on purpose because he monetizes greatly off of taunting him online. So, to the court's tentative about the hotel situation, another situation with Santos, Brianna's testimony about that was not that she was there. It was that the specific commentary about Chris knocking on the door and the "we" words was about the day before, not the actual video of Santos and another man outside of John's hotel. And again, John is claiming that his peace was disturbed because he was scared of Santos in general. He claims that his peace was disturbed on that evening, that Santos was allegedly outside, but then he, again, says, I purposely taunt this person online for money. So I'm not really sure how credible it is that he is afraid of this person, or in particular, he was afraid of this person that night when he was nowhere in the video. He didn't come outside, and Santos was not here. Santos was not subpoenaed as a witness, so nobody laid foundation as to when that video was actually shot on Santos's phone. Do we know it was actually that night? No, we don't. John says he knows because he was staying in the hotel that night, but there was no, as the court brought up, no metadata from someone's phone, no custodian of recording from TikTok or Snapchat or whatever that video came from. No subpoena to the party that actually shot that video to pull it up on his phone and show that it was that night that John was actually staying there. So again, we are missing a lot of pieces to connect the dots. That was even an authentic video shot by Santos when John was actually in the hotel. And then certainly major credibility concerns regarding his alleged fear on that night. or just to Santos in general, when he says he purposely pokes the bear online to make more money. John also said his peace was disturbed when Brianna accused him of SA online, but then confirmed through his own testimony that it wasn't actually her accusing him of SA on.
Counsel, respectfully, I know you got a lot, but I would like you maybe just to direct your arguments to the tentative in my ruling, because I said the basis of my ruling is not these alleged defamatory statements. I mean, you can, but I think I've been very clear about the basis of my ruling.
Miss Fonseca? Okay, so if we're just talking about the hotel then what I just said would be, I guess, my rebuttal to the court's tentative is Santos was here. He knows where Santos is. Santos could have been subpoenaed. We could have subpoenaed the custodian of records to Snapchat to verify when a video was actually taken. Just because Santos posted a video showing a hotel sign does not mean he was there when John was actually staying there. John has offered no testimony to say, I knew he was actually outside. I went to the front desk and peeked out the window and saw him. I called the front desk and had security go outside and check. I had a note on my car that he left. He gave no testimony to connect the video of Santos, which again, my client is not in the video. She is not heard off of the video. Her testimony was that the "we" comments and the specific comments about knocking on the door was a separate incident the day before, which is not the basis of John's allegation of fear regarding Santos, not an allegation of fear regarding Brianna. So again, if that is the hyper focus of what the court is saying is I guess a credible threat or John's credible claim of being afraid, I would say we're missing a lot of pertinent details, which would be the authenticity of the person's body actually being outside of the hotel making this threat when John was there, because
Hold on real quick. And then also, just the other. I don't want to keep cutting you off, but I'm worried we're going to run out of time for custody and visitation. So I'll let you finish on that. And the court's basis wasn't only that, it was all of the threatening statements that I read. So I don't think it makes sense to address the alleged defamatory because I was pretty clear about my ruling on that. So anything else on that?
That's me, sorry.
Okay.
Miss Fonseca. So as to the two where she is wearing the sunglasses and saying something about kidnapping, her testimony is that she was reading the TTS, the live chat comments during her kick stream, making those comments, so that wasn't, and she also testified that that was a joke. She never intended to kidnap W from his supervised visits in Dallas, which was another clip that they played, and that she was just reading the live stream chat during the sunglasses clip that we watched. And on the boat clip that we watched at the nighttime, well, I guess I should say, as to all of these clips, she testified that W wasn't there and it wasn't her custodial time. But as to the boat clip, as she testified, she was just saying that if anyone takes her baby, it's going to be a problem. She didn't specifically say Jennifer. She didn't specifically say John. So I think that somebody that is served with a restraining order, ex parte, etc., within 1 month of giving birth after going through a pregnancy by herself, being in LA by herself, and all of this being on the internet, certainly gives her an emotional basis on which to direct general comments as she testified to the world that she was upset, that she feels like everybody is trying to take her baby away.
Did she have any testimony that she was served with a restraining order 1 month after giving birth?
Miss Fonseca, yes. Miss Budnick, no. The restraining order wasn't even brought up. We had a lot of arguments over whether we could even mention the prior restraining order. It was not even brought up.
I don't believe there was any testimony.
Miss Budnick, there wasn't.
When she was served with the restraining order, and that was a month after giving birth, I do not hear any testimony. We're going to run out of time, so I'll give you a few more minutes because we still have to do custody and visitation. She has to respond.
Miss Fonseca. So I think the only other ones left that you were mentioning is the two different video clips of her mentioning burning a city down. John's testimony and his mother's testimony was that we assumed that Brianna was talking about this about us and our city because we just made that assumption. There was no testimony that drew those comments to John, or those comments to Dallas, or those comments to Grandma. And Brianna's testimony was also that I was just making those comments in general. I wasn't directing them to anyone.
Yeah, because that's a normal thing that somebody just randomly says. Like, what? Sorry.
I've never said it.
Yeah,
Ever.
like, what? That's crazy. But okay, go carry on.
I mean, people make me mad, but I don't. I'm
Right.
gonna go do this.
That's craziness.
And just really quick, the whole fact of like, we don't know if Santos was at the hotel. That was probably another day. Yeah, because you just randomly go to a hotel and video yourself at a random hotel knocking on doors.
Right.
On your free time. Like, I don't.
No, he was there. They know exactly what they're doing. And we're almost done. We only got, I think, like 10, 15 pages left to go. And then I'm going to sum it all up at the very end, and we'll finish up. I do appreciate you guys hanging strong with us. We're way past the time we were said, but we are going to finish up. Okay, go ahead.
Okay.
Oh, no.
To the court's point about the directiveness of alleged threats, this is Brianna talking and repeating what people are typing on a kick stream in a live chat. On a kick stream and live chat. And I didn't repeat that, she said it twice. And then other people clipping these and posting them all over the internet. And like the court said, John claims that she was blocked. But he also claims that he is continuously seeing this stuff. So I don't know if that's credible or not. But she's not making direct threats at John. She's not making direct threats at Jen. She might have called Jen fat. She might have said that she doesn't like John's hair. But is that enough for a basis of a restraining order? Again, this is not a CHRO against Mom. Mom was never listed as a protected party. These are not direct threats. These are public figures. This is not my client. This is not my client ever once blowing up his phone, blowing up his text messages, having Santos or anybody else on her behalf doing anything like that. And the cases that we cited in our trial brief are clear in the restraining order context, and specifically the case the court kept bringing up today. The restraining order, I guess, field is not the place to settle disputes between ex-lovers. This is to protect somebody's peace, and I don't think that any of the testimony that Dad gave about his peace being disturbed, especially based on the week of the kidnapping and what happened during that week, was credible whatsoever. You don't drop a diss track about your ex-girlfriend the same day you file an ex parte motion based on the kidnapping and then stream the entirety of it and admit to making 6 figures off of it in a single week.
Okay, Miss Budnick. No, I feel like you just read so much. Are you good to read this, or do you want me to help you out? Or are you good?
I'm good.
Okay. So this
It
is
is a
Miss.
lot,
This
though.
is This is Miss Budnick's closing, and then I'll do the final ruling.
And then this is John's attorney, Miss Budnick. So first, I do agree with the court's tentative that my client has met his burden to show a permanent restraining order is warranted. Specifically, Family Code Section 206203 allows a restraining order to be reissued based on the types of conduct that can be enjoined pursuant to Family Code 6320. That section is very clear that threatening conduct is the type of conduct that can be enjoined. It's a type of conduct that warrants a restraining order. While I also believe that there has been harassing conduct, I do think that it is neither here nor there at this point, because the important thing is that a restraining order will be issued to protect my client. The court needs to find one incident of abuse to issue a restraining order. I know my client has presented evidence of countless threats, not just statements that are online bullying as they've been described, or statements that disturb his peace. We are talking about direct and explosive threats. I will F you up. I will F you and your mom up. Threats that are communicated on the internet, and threats that are communicated in person, and threats that have been communicated after the temporary restraining order was issued. A violation of temporary restraining order also gives the court grounds to issue a permanent restraining order. My client has effectively been terrorized by Miss Olson since January of this year, at least as far as the evidence we presented today. The threats predate the March 25th incident that we had focused on, and there are threats that occurred after the March 25th incident that we had focused on. I think he has more than met his burden to show the AB has occurred, and he needs a restraining order for his protection. And I agree with the court's tentative.
All right, thank you. So because we went in a weird order, I'm going to give Miss F the last word but to say, if you want to contest anything she said or anything that hasn't already been said.
And then Miss Fonseca, just refocus on the hotel piece. That they had the opportunity to bring in this witness and to bring in actual ways of authenticating that video, and none of that was done. I assume strategically, because John, again, did not testify that he had any basis on which to claim that he knew Santos was outside, besides the fact that Santos uploaded a video while he claims he had been staying in the same hotel. So honestly, for lack of better term, I find that to be extremely flimsy evidence when this person is local. The metadata could have been subpoenaed. This trial has been on calendar for a very long time. So if that was their biggest piece of evidence, I would say the connection to it actually being authentic evidence that he was outside, again, without my client there. Nobody ever said my client was there, was off site with the camera or anything. I just don't think they met their burden on that one piece of evidence when there are easily accessible ways to authenticate what they are saying was real, but those steps were skipped.
All right, submitted.
Ms. Budnick, submitted.
All right. Evidence can be authenticated a lot of different ways. Certainly, you can bring in metadata. But a party can also testify that accurately looks like the hotel I was doing. I think he talked about a social media convention. There were all social media stars, including Santos. He testified he was there, and then shortly thereafter, he had Miss Olson's testimony. And again, it is not beyond a reasonable doubt. It is a preponderance of evidence. The fact that somebody didn't bring in evidence, in a criminal law, there's a jury instructions not to necessarily consider all of the evidence that someone couldn't have brought it in. There's also, even in the beyond a reasonable doubt context, the testimony of one witness can be enough to dispute that. Mr. Gacy testified he was there Mr. Santos, I don't know what his last name is, has put himself there. And then we have the corroborating evidence of Miss Olson, sort of corroborating everything. But that wasn't the only thing. It was the other threats. So the court, and you will note, I didn't spend much time on what happened with the exchange of the child. I did not, because I think it was equivocal, and I think that that interaction is the kind of thing that those cases talked about, where not all custody disputes can be based on a DVR. I'm not sure. I'm not sure. It was awful to not know where your child was, but I do think that the physical evidence, the videos we saw, were not necessarily consistent with Mr. Giese or his mom being particularly upset. They were live streaming. There was no evidence of the throat. Thank you guys so much for the gifts. No evidence of the throw. He had to film the throw up and send in a picture. I'm confused on what she means. Anyways, etc. But again, that's not what the court is focused on its ruling. It was the incident of the hotel and the prior threats, and of course the behavior during the incident, The water pews, I guess, had some weight to it. Again, those alone may not have been enough. So for all of those reasons, I do believe it is appropriate to issue a restraining order. I will say this. It's going to be a short one. It's going to be for 1 year. And I'm going to order you to do a parenting class. Not a DV class, a parenting class. Bree, did you hear that? Because I know you watch. She's ordering you to do a parenting class. It's for 12 weeks. It's due by January 6th. Just thought I'd put that out there. Anyways, my understanding, I believe your client is with child again, correct?
Miss Fonseca is what?
Miss Fonseca as I read through this, she is going to divert from answering this question every single time. So the judge just asked, my understanding, I believe your client is with child again. And let me also remind you, Miss Fonseca is a mother herself. So as a mother, you know what that term means, is with child. So okay. So she's with child again, correct?
Is what?
With child again?
Miss Fonseca? Yes, she did do one of those paid parenting classes through Cornerstone. That's on the court's list.
What does that have to do with her being with a child? So this is number one. There's going to be, I believe it's 3 times. This is number one. Oh, yes, she did do a parenting class. Nothing to do about the pregnancy. So why won't her attorney answer it? Right? So I just want to point that out. So then the judge says, how long is it? How many weeks? How far along is she? How many weeks is she?
And then Miss Fonseca, it was private, like a private thing with the owner where they did private lessons.
Right. And then Miss Olson pipes in, private sessions, and I took a test. I think I offered to do them alongside John, which was the offer of the owner of the company. Because, bitch, you took a co-parenting class. You did not take a parenting test. You took a co-parenting class. John didn't need to take the co-parenting class either because John already took the co-parenting class in the beginning when it was ordered. He didn't wait till the last minute. And you took yours on kick. You didn't take a test. Your stream took a test because you asked them all of the questions. But I'll continue.
There's a huge difference between co-parenting classes and parenting classes. One teaches you how to co-parent and one teaches you how to be a parent.
And so the judge says, because she said that, I'll read it again, private sessions, because, she's bougie, she's Miss LA, and I took a test. I think I offered to do them alongside John, which was the offer from the owner of the company. The judge then says, oh, wow, I'm going to order him to do one separately, which he had already done. Bree then says, I did one recently when you ordered supervised visits. The judge says, good. Now, first of all, why she's even speaking up and her attorney hasn't zipped her, I have no idea, because that would be a typical thing. Do not say anything. You are the client. I am your attorney. I will speak on your behalf. Shut up. But she's just letting her go. The judge says, good. Miss Olson says, that's how recent it was. The court, okay, because here's what I'm going to do. I'm going to make the restraining order valid for 1 year. We're going to come back in 6 months because under 304, I just thought it was funny that was code 3044. Anyways, I'll be sometime. There is a presumption against joint legal and joint physical, and you can overcome that presumption with certain things. DV, which I don't think is appropriate here, but parenting classes is. And so if you come back and show me your parenting classes, which we know has not been done, parenting classes, the court may very well consider changing the presumption. We're now on to, let me read the order real quick because we're running out of time. I'm not going to make any special orders regarding enjoining particular conduct about posting because my fear is that will be challenged right away and may not very well be successful. I'm going to follow the standard orders in a DVRO. I'll leave it to the both of you and you guys both have phenomenal attorneys. Well, at least one of them does. You really do. And I will leave it to them to provide you guidance to whether or not something is violating or not. Bree, you may want to seek a second opinion. Just putting it out there. So it's going to be, I can't prohibit them from posting. I recognize that's how they make their livelihood. I'm going to prohibit them from making defamatory statements. I'm going to read that again, Bree, because I know you watch. The judge says to you, Bree, I'm going to prohibit them from making defamatory statements. You are prohibited, Bree, from making defamatory statements against John from the date of this order till you go to court until August of 2026. But I will continue. I hope you wouldn't because that's a separate issue. You have a child together, and you have said some horrible things about each other online. Absolutely horrible. And now I'm putting on a different hat. I've now moved away from my DVRO hat, and I'm now on to my custody and visitation hat. And that kind of stuff I can take into account when I make custody orders. So you both need to prove to me that you can do a lot better as it relates to your child and what you say about each other. Because W is going to get old enough at some point to go look at all that stuff. He's going to see what you said about his mom. He's going to see what you said about his dad. Think about that. When he's 12 years old and he's in middle school and he's embarrassed and he has all his new buddies and they're going online, hey, see that your mom said about your dad when you were little? Hey, see what your dad said about your mom? I feel sorry for him when that happens. So I want you both to think long and hard about that, all right? Miss Olson, you are ordered not to harass, strike, threaten, assault, sexually or otherwise, hit, follow, stalk, molest, destroy the personal property of, or keep under surveillance, impersonate, block movement of, annoy by phone or other electronic means, or disturb the peace of Mr. Gacy. Disturb the peace means to destroy somebody's mental or emotional calm. This can be done directly or indirectly, such as through somebody else. This can also be done in any way, such as by phone, over text, or online. Disturbing the peace includes coercive control. Coercive control means a number of acts that unreasonably limit the free will and individual rights of the person protected by the restraining order. I didn't see any evidence of coercive control, so I'm not going to go over that. You must not contact Mr. Gacy directly or indirectly by any means, including by telephone, email, or other electronic means, except do they do Our Family Wizard?
Miss Budnick, they do use Our Family Wizard.
Except through Our Family Wizard, there's an exception to that. You may have brief and peaceful contact with Mr. Gacy to only communicate about your children for court order visits. You may have contact with your child W only during court ordered visits. We're going to talk about the visitation in a second. You must stay 100 yards away from Mr. Gacy and his home. For an exception is for the exchange of the child for court order visits. You must do so briefly and peacefully. For you to visit your child for court order contacts and visits. I'm going to order you to do a parenting class. If you've already done one, great. At least 12 weeks. So I know there's a private, but there are court-ordered sponsored ones that I really would like you to do.
And Miss Fonseca, it was at, oh my goodness, it was the facility on the floor of the LASC.
Okay, she can turn it in, and the court will take it. Okay.
And Miss Fonseca, we already did file that.
Okay, we'll just put that as already been filed. Do you have any objection to what are you aware?
And Miss Budnick, I don't know the details of the class, and I think if it doesn't meet what the court has in mind, I can make my objection.
I'll say anything already completed may count, so I'm not going to make her do any more.
And Miss Budnick, okay.
Okay. Mr. Gacy may record any communication you make in violation to this court, all right? Here's what I'm going to do regarding custody and visitation. Right now, I'm going to award sole legal to Mr. Gacy. I think I have to under 304 for presumption, but you can overcome that presumption. You can overcome that presumption by taking parenting classes. I am going to order I am not going to order supervised visits anymore. My understanding is that supervised visits have gone well. There's never been any physical harm to W as far as I can see. However, I do not like videos and pictures of your young child on the bed and people are vaping and smoking. My understanding from your attorney, you are no longer living at the MILF house. Is that correct? Bree responds back, I have my own apartment. The judge, wonderful. All right. What I would like to do, so I'm going to say no travel with W outside of the state of California during your custodial time in California. You are not going to have custodial time in California right away. Thank you guys for the daily heart means we're almost at 400. You'll eventually get it. Or you can't take W out of Texas during your custodial time in Texas. My sense is, this is where I'm concerned about the judge's senses. My sense is you've learned an important lesson about this whole thing with LAPD. Thank God nobody got hurt. But they could have been. When our law enforcement shows up and says they're outside, it's not a joke. When I asked how old your managers were, I don't mean to be disrespectful, but a 21-year-old and a 22-year-old does not know the law unless they went to law school. They gave you terrible advice. I heard it all. You were lucky you were not arrested. You were lucky no one was hurt. When law enforcement says turn over your child, you turn over your child. You have to do it. My sense is because you're a public figure, you are not going to do that again because they know where to find you. I think right now there is a lot of basis for supervised visits. I would like you to have, I think right now there is not a basis for supervised visits. I would like you to have overnight visits with your son. I know you're dying for it. I know you do. My sense is you're a different person now than you were a couple of months ago. You're a young woman. You are going to continue to learn. You have another child coming soon. You both make your living on the internet. I've heard so many things that just really cause me such great concern, but there's nothing I can do because you're going to continue to do it because you continue to earn money. And it is what it is. But I can take into account what you say and do on the internet in terms of when I award custody and visitation. You are not scot-free in this, Mr. Gacy. You said some horrible things. You made some you made some really bad choices, I think. I understand that's how you make your living, your life, your living. It is hard for me too. I will say it is hard for me to hear that you were stressed out about these other things and then you're posting in the hallway and you're making videos about it. It rings a little hollow. I mean, it was enough for the DVRO, but it rings a little hollow. So either you care about your child and want to raise your child. Don't talk the way you talk about your child's mother on the internet. Same thing with you. You guys may ignore me because you make a lot of money doing it. That's your choice. But my sense is the other side will bring me in those videos the next time we discuss custody and visitation. That's why I'm allowing her to have unsupervised visits. Remember, I keep telling you guys, everyone keeps saying we need a new court, we need a new judge, we need a judge, we need a judge. I keep saying, hold on, tigers. She doesn't have enough evidence because it's only been supervised visits, which of course she's on the up and up and up and up, right? The judge is like, she has to have the evidence. Here's the rope. Here we go. This is why I'm allowing her to have unsupervised visits. What I'm going to say is, let's do. Did her girls have a chance to talk? Or this is when we're going to have a chance to go in and meet and confer. This is the drinking game of the 4:30, etc. The judge needs her to have that time to be able to spend time with her child and see how she acts. Has anything changed in regards to her behavior? No. It has not changed at all. Her behavior has stayed the same or even got worse because she feels like she's able to get away with all of the stuff that she's doing. Again, the best thing that she can do. And everybody wants her to be a great mom. Everybody wants her to have time with her child. Everybody wants baby W to have the best mother he can. And if she's not ready, then she needs to figure that out. But again, she has not yet done what the judge says she needs to do. She needs to do 12 weeks of parenting classes. That has not been done. She needs to have a residence in California. She doesn't have that as of yet. But anyways, I will keep reading. This is when they go back and forth. We did read this recently about the meet and confer. Did you guys have a chance to meet and confer? And then we're on line 17, Miss Budnick.
We didn't. My ask would be, at least initially, that the visits take place in Dallas, and I would ask for an order that Santos not be present at the visits in any capacity.
In any capacity. Right? Remember, if you guys were here, I looked that up. What does that mean in the California state law for family court? What does any capacity mean? In any capacity means to not be a part of visits in any way, shape, or form. Okay? That means the planning of, that means him being at the house, not just around W, right? So say her and W are out and he wants to come by the house and pick some, he can't do that. through the whole time of visitation, right? So just for namesake, we're going to do, say, it's Monday through Sunday. That's her visitation. So Monday through Sunday, no FaceTime, no texting, no calling. He can't be in the yard, in the car, in the house, at the anywhere they are. He cannot have in any capacity. Okay, in any capacity. So again, that last one, I would ask for an order that Santos not be present at the visits in any capacity. And the judge says, oh, that's absolutely going to happen. I am not going to bash. I do not know if he's the father of your other child, but he's made some poor decisions. He should, I will. I will. Why don't we put in the order he cannot film? You just said film was. I do not want Santos at those visits. There was already an incident. I don't know whose fault it is, but there are those people who are red flags for other people. He is a red flag for Mr. Gacy. So you should focus your visits in Texas with your child and not Mr. Santos. First of all, Santos is a red flag for the majority of people. Okay, he's just a walking, bucking red flag. Number one. Bree, the judge says right here, clear as day. After she told you she feels that you've learned so much and you've come a long way, and she's going to know come January. She literally says right here, you should focus your visits in Texas on your child and not Santos. Not Santos. So here's what I'm going to do. I knew we were going to run out of time, all right? I was hoping you guys were going to meet and confer. I guess that didn't happen, so let's do this. I'm going to set the 6-month review date. I hate to do it, but I'm going to do it. Right now, all visits will occur in Texas unsupervised. The parties can meet and confer as to the schedule for those.
Miss Fonseca, Your Honor, that's not gonna work.
Well, it's 4:30.
Miss Fonseca, I know.
Counsel, respectfully, I said from day 1, day 2, and day 3, we're going to run out of time. That's why this morning I said I would like you all to meet and confer. Nobody did it. I'm at 4:30. I've given you guys a day longer than this case could have taken because nobody followed my order. So you're going to meet and confer. You're going to meet and confer. That is the court's order. That is this court's order. All of the visits, we're at 4:30 right now. We had 3, 2 days. We had 3, 2 days. What? We had all of lunch to work this out. You did not. I am not keeping my staff late because you guys didn't meet and confer. So all of the visits are going to be in Texas for the first 6 months. You guys can meet and confer on a schedule. If you meet and confer, my sense is someone will come to the court with an RFO. When we'll do a 6-month review, when she shows me proof that she's finished the parenting classes. You gotta finish the parenting classes, Bree. And all of that, and assuming those visits have gone well, then we'll discuss visits in California. So what did the judge say? You have to finish your parenting classes and all of your visits have to go well. But there's been issue after issue after issue after issue with every single parenting class. Every single visit. Yeah, please keep tapping. They'd love to come report me. That will be the court's order. Let's get a review date.
Then Miss Fonseca, it's Texas, right? Then Miss Budnick, not Dallas?
Dallas. It's not in California.
Then Miss Fonseca, no, because the airport. Then Miss Budnick, Texas is huge. Then Miss Fonseca, borders a county line, so the airport is actually closer to a county that's not Dallas County. So is it Texas as a whole or Dallas County?
And then Bree says, I would have to get an Airbnb out in Dallas County where my family doesn't live in Dallas County. The judge, okay, where does your family live? She says, they live in Corpus Christi, Texas, and they live also. The judge says, where do you live? John says, I live in Dallas. The judge says, okay, again, this is why I said meet and confer. It is now 4:30. Your attorneys were told at 10:30 today we were going to run out of time. I told them to meet, they did not. I'm not letting my it's on you guys. Here's the order. If we met and conferred, we wouldn't be here now. So where does he live?
And Miss Budnick, the child and my client live in Dallas. Corpus would require a flight. So if it's in the vicinity of Dallas or surrounding counties, I think that's probably a fair compromise.
Okay, here's what I'll do. I am urging both of these attorneys to work together. The visits will be in Dallas and surrounding counties, except if you guys can work it out amongst yourselves.
And Miss Fonseca, and overnights, correct?
And they are overnights. They can be 3-day weekends. I'm good with up to 3 days. If she wants more, you guys can meet and confer on that.
And Miss Fonseca, okay.
So at least, let's say once a month. Let's say once a month. It can go up to a week. This is why, again, when I said meet and confer, this is what I meant. I did not want to be doing this at 4:30, and here we are.
And Miss Fonseca, okay.
She's pissed. So she can have at least up to a week-long visit a month overnight with, and maybe that will negate the issue of travel, because if she has a full week, she can work out her schedule. The parties are ordered to meet and confer regarding that schedule. Up to a week, once a month, unsupervised, in Dallas or surrounding counties. We will do a 6-month review date, assuming those are going well. What's happening here? There you go. Sorry, those are going well, and the court will switch and have some of those visits in Los Angeles, assuming she's still living there. Remember, she doesn't have a residence there right now. Santos is not to be present in any of the custody visitations in in Texas. That may change. My sense is that as she gets more pregnant, there may be harder issues with travel, not Travis. We'll address those when. I think we can set this for the move away, because don't we need to do the move away at some point? Did you hear that, Bree? Did you hear about the move away? Remember, she was saying, I don't know if you guys talking about the move away. Just read the transcript. It's in the transcript. We're not doing a move away. I can read it for you again if you need to. Let me know. Doing the move away.
Then Miss Budnick, at some point we're going to need final orders, so I think that would make sense. My only other question would be, can we get an order that Miss Olson provide the location where she'll be with the child via OFW?
Absolutely. Let's talk about that. Let's read this again, guys, because remember, we just went over remember when Bree's attorney refused to provide any of the verification and said it was too much. He doesn't need all of this information. At some point, we're going to need final orders. So I think that would make sense. My only other question is, could we get an order that Miss Olson provide the location where she'll be with the child via OFW? The judge said, absolutely. Absolutely, you can get that. Absolutely, she must provide the itinerary for the child. Okay, sorry, go on.
Then Miss Budnick said, okay.
All right, let's do a 6-month review date, and maybe should we set that? Why don't we do this? I don't want to do 6 month. Let's do a 3-month review. And at some point I want to. She's going to get more pregnant, and then there may be an issue with flying. Let's see how the Texas things are working. Miss Fonseca can bring me all of the proof and just argue it again about the parenting classes. At this point, I'm going to set a PPA also, probably in conjunction with the move away order again. So let's do the first 3 months. She can see W for up to a week in Dallas and the surrounding counties. Santos is not to be present at any of those visits. You have to abide by this order. It is going to be up to you to make a determination of whether what you post on the internet violates this order. You have a very good attorney next to you, and I'm sure she will provide you with that guidance. Hopefully, the parties can meet and confer on a holiday schedule.
Then Miss Budnick, definitely.
Because I definitely don't have the time to do it. We'll set a review hearing date. You guys can always file an RFO. Well, why don't we just do...
Then Miss Budnick, I'm pretty open in January. It's just the last week of January I'm out.
My sense is on that review date, we will discuss switching the visits to California. Can we do January 8th?
Then Miss Budnick, I can do January 8th, 8:30.
Yes. What day of the week is that?
And Miss Budnick, a Thursday.
Okay. Can you guys do January 6th?
And Miss Budnick, that also works. Then Miss Fonza, that's fine. Fonseca, that's fine.
All right. Okay. So I think I've said enough. You'll get a copy of the order. I wish you all the best of luck. Remember, everything you post, the other side is going to see. And if the other side sees it, you can guarantee they are going to show it to me.
Then Miss Fonseca, is that 8:30?
Yes.
Then Miss Budnick, I think respondent needs to wait for the restraining order to be served. Can I pull a copy from the court website?
Sure.
Then Miss Budnick, okay. And that way we're not all waiting.
Okay. Best of luck to all of you. So that is the whole, that's not actually the whole transcript from the trial. That's just the last day. There's 3 other days of transcripts, guys. So that is a lot. Okay, that is a lot.
Well, it's half of the last day.
Yeah. And shout out to Bailey for coming in and reading with me, because it makes it so much easier. I so appreciate you guys. I appreciate you. But let's,
of course.
I mean, we're already late, so let's tap away. You guys are amazing. 250. You guys are 250,000 taps. No, you fell asleep. I will upload this. I will upload this today. If it uploads quick, I will get it over on my YT today. If not, it'll be on there tomorrow. But let's dive in a little bit. Also, too, you guys, thank you guys so very much for everybody who sent me gifts. I know I didn't get to see all of them. To thank you guys. I appreciate you so much. Thank you.
Same for everyone who sent me gifts.
Yes. So I want to do a quick poll based off of everything that was just read. Do you feel that, it'll be red yes, blue no. Do you feel she's going to be able to get visits in California in January? Red yes, blue no. Based off of what the order just was, will she get visits in California? Red yes, blue no. And again, we did do little bits and pieces of our input, but that was basic. That was just reading directly what the judge and the attorney said. Thank you so much. Oh my gosh, you guys are, oh my gosh, my lip gloss. We're almost to 400 daily heartbeats.
You have the one yes from Brie or Santos, whichever one it is in here.
They love coming and hanging out.
Oh, both of them now.
So funny. Yeah. JJ seal the yes. Whoever voted yes, Bria Santos, right? So, we're going, you guys, we're going directly off of what the judge said. I think the judge was very, very clear, very stern on what she said. I will admit, I will always admit when I think something is a little wonky. Just reading, when you read through that, it almost at one point almost sounds as if the judge is like, oh, okay, yeah, just turn in whatever it is that she had for her parenting stuff and we'll accept that. She does then later go on to say it has to be approved, it has to be the 12 weeks. So if you're only reading bits and pieces, that could be confusing. But again, she also said too, they are not to say anything disparaging or defamatory against each other. And she asked, Marie, thank you so much, love. Listen, I love every single gift, but whenever somebody comes in and gives their first gift ever on TikTok, and it's to me, it really truly means the world to me. But when she said no defamatory statements at all, and she this time she asked for the videos. It is gonna be, listen, January's court is gonna be very interesting. Very, very interesting. So I don't know. Thank you, Marie. Yes, I was confused about parenting classic. Yeah. Ren, thank you so much, you guys. And then February
Bree's
court too.
lawyer.
Huh?
Oh, someone said, how is Bree's lawyer not checking her right now? She is doing opposite of what the judge says. And it's because I think Bree's attorney, for one, isn't fully, like, she's new to this field and she thinks what Brianna is doing is okay, I feel. Like, she is like, oh, you're fine, just don't go beat him.
I just don't even know if she even pays much attention, or if she just kind of at the point of she's not going to listen to me anyways. So have at it. You know what I'm saying? I don't know.
And like someone said, she's getting paid either way.
Well, yeah, her license. Yeah, she has to be a valid attorney if she's practicing in front of a judge. Absolutely. Court in February, from my understanding, is going to be from the motion that I read over the other day. Remember, it was the 12 demands that they had to do, and those videos are all up. The whole 90-page document I read, that is on my YT. So make sure, if you guys aren't following me here, make sure you guys follow me here. Also, my YT page is the same as here. Angie W1470. You can go over there and read that. Thank you, Sammy. The motion to go. You can follow over there. I read the whole 90 pages. That's on my YT. And then over here, I broke down each individual demand. There's 12 demands. The one thing I was super confused on that is Bree's attorney asked for an extension. January 6th is the first court date, and then February 8th or 9th is the second one. She asked for an extension on the demands and then denied every single one. So I was confused on why she even asked for an extension. And then John's attorney filed a motion to compel, so that will be heard in February. And again, if you haven't heard that, all of that was just providing the normal verification needed for her to have visitation in California. So I'm super confused on why they wouldn't have turned that in. I just don't get it. But what do I know? I think she was trying to get them from Brie, but never got them. Oh, maybe that's a good possibility, Katie. Probably because Brie didn't turn anything in. Yep. You guys all said you guys are so smart. I didn't even think about that. Yeah. Yeah, they gave them a 1 week extension, which was the exact extension that they requested. It kind of looks like 2K is a little controlling because they're going to get married. What? First of all, I don't think 2K gives two craps about if they get married or not. Second of all, I don't even know if that was a real engagement thing. You know that all that stuff is just set up there, and people like line up to use those places as photo pop. So I don't know, but yeah, I can pretty much guarantee you, 2K does not give two shits if they get married.
I think the judge will hold Bree accountable. I do believe that she has to
Yeah.
give her enough rope to fully hang herself, because in the past there was tiny little loopholes she fell in.
Yep.
So I do think the judge was like, here you go, I'm giving you what you want. Show me you want it.
Yeah. So now reading the transcript, how do you think court will go? I still think the same. I had read the transcript before, when we first got it, but I think it's going to go the exact same as what I thought. I think the move away order will be granted. I think visitation will remain in Texas. Yeah. I think that's kind of all there is, because there's no custody, right? John has 100% custody. She has no custody of the child. She only has visitation. That is not going to change, because in California, if there is a DVRO, you cannot have custody of the child. Now, the judge said that she would be willing to make some changes if she took her parenting class, the 12-week parenting class, and if everything went good, there was no problems through all of the visitation. She only had to do 3 months of visitation, good, with no problems, and that didn't go. And she has to have a residence in California, and she does not have that right now. Can said, will that affect January court case because they won't have proof she completed it? Yeah, it'll probably just, the only thing with January is the hopes of having custodial time in California.
Because she is pregnant and won't be able to fly, because she's supposed to be like 8 months pregnant, or like 7 at that point.
Yeah,
7 or 8.
Yeah. Her going out during her visits will not look good. Potentially. I mean, just in general, it's not really good. Like, you only have the child 7 days a week, but she will be able to say that she was, that it was a work thing and she did it to have money, whatever the case may be. I don't know if it was her mom that was there that babysat. Hopefully, because I think that was the only person that was approved. I don't know. Um, so the judge may, who knows on that one.
It's hard because also in the transcript, the judge does say, like, with the 1 week, you'll be able to rearrange your work schedule and to focus on your baby.
Yeah. And the whole thing is focus on the baby, right? Don't focus on, she literally says, focus on your baby, on your son, not Santos. And we're going to see that there's just a whole lot of Santos. Santos, if Santos truly loved Brie, right? We're just going to pretend. Now, I grasp that he's very young, so he doesn't quite have that maturity yet. If Santos truly loved Brie, he would step away for that entire week and just let her have her one-on-one time. But then when Bree, this last visit, she was only there, what, not even 12 hours. She's like, oh my God, this is so hard. I can't do this by myself. I got to have somebody come in and help me. So who knows, I just don't know. All of the different fighting and stuff they're doing. How old are they? Santos is 20 and she is 25. That's a possibility. I'm the pro. That's kind of, I think, what a lot of people are thinking. I personally don't really like to talk about pregnancies and stuff. I listen. If she has a baby, she has a baby. She doesn't, she doesn't. It's kind of my thought. I don't ever like to talk about it. That particular work was last. Yep, a last minute thing. It could have waited. I agree. Yeah, they're very young, and Santos is a very, very young 20-year-old. She's a very young 25-year-old, but he's very, very young and immature. Thank you guys so much for the gifts. I so appreciate you guys. All right, any last few questions? Bree slipped up. He's only. Oh, you know what? I did hear that at dinner the other day. She was like, "You're only 19." Something along those lines. But for some reason, I feel like somewhere. I don't know. I'll have to look into that. Oh yeah, Bree's definitely I mean, but Santos is the problem too because Santos needs to man up and be able to tell it, no, I'm not going to go do this. No, I'm not going to go and do that. You know. I got a question. Can you let me? It was kind of, what? How long? Because I'm trying to get off. How long? I haven't even had dinner yet.
Me either.
Yeah, is the way. Oh, feel free to drop down, Bailey, if you want to. If you want to go eat, I'm gonna just answer a few last questions and then I'm gonna pop off. Bree is the one.
Okay, I'm gonna hop down so I can eat dinner and get to bed. I have to be up in like 5 hours.
Oh my gosh, love. Go get some rest. Thank you again so very much for coming up and reading with me. I so appreciate you. Have a good night,
You're
and I'll talk to you
welcome.
tomorrow. All right, bye.
Bye.
Doesn't the judge frown on her providing? Well, one would think. I don't know if it's been brought up. I don't know. Can you clarify the flight with the lawyer about the hotel? Oh, is that fight? Okay, wait a minute. What's your question, Angela? Can you clarify the fight with the lawyers about hotel? What's your question? I seen somewhere that they are getting married because then he can't testify. No, that I think that's in a criminal court. Like if you're in a criminal court and you're against somebody, whatever, yeah, you don't have to. You can't. They can't force you to testify against your spouse. That will have nothing to do with a custody case. No proof I have. He's 19. Only his mom's mouth. She is disappointed and wants nothing to do with him. Oh, his mom said he was 19? Mmm. Oh, that'd be hilarious. Was that your question, love? German tea? Was that your question? Is it about them being married? Wait, hold on. I want to make sure I answer the question about the fight in the hotel. So if you can put in there if that's what it was. To be honest, I don't think they're getting married. Yeah, you guys, I think a lot of that was a skit again, especially once I saw that all of that stuff is just set up and it's just like photo stuff and people are lined up to go take it. Yeah. Okay, the fight about the window, 2K calling the first floor confirming. So basically what happened, and this is basically what happened is Santos and hey pup mom, Santos and some other people went to his hotel where he was staying, and Bree was you could hear Bree saying, "We are there. We went to his hotel. We are going to do etc." Right? And so the judge took that as a viable threat, and that is one of the main reasons why the DVRO was granted. They actually didn't run into each other or see each other, but it was the fact that they went there to do that. We're outside, come outside. And yes, that is absolutely a terrible thing. But I thought that the fact that, hey, Teresa, the fact that the judge, weighed so much more on that than I'm going to burn your city down. I'm going to shoot your mom in the face. Like all of those other things. Like, I mean, they were bad, but the judge was hell bent on the fact that you actually showed up at the hotel. Yeah, Breeze. And again, I know people think that I don't like Brie and I want terrible things for her, and that's not the fact at all. In reality, I would love for her just to listen and to make changes so she can be the mom that baby W and this new baby deserve, right? Because what's going to happen when, anyways, I'm not going to cover the new baby. Once this court case is over, I'm done. I'm over it, right? But I just wish you would listen to what the judge was saying and just chill and just act appropriately. And I can't want it more than she wants it for herself. yeah, all those little things. If they have pictures of it, if it gets brought up, it gets brought up. I don't know about the view on table. Yeah, no, I definitely get that, Teresa. That it showed that there was action behind those words, right? But then to me, it makes think, okay, there's action behind the words because they actually made the steps to show up. But I would think all those other threats then would be have just as much action since they have shown that they're willing to go through those processes and step up. So I don't know. So crazy. All right, guys. Well, I am starving. I'm gonna eat. First, I have to make dinner. This is gonna be a late dinner. Do you think she's going to make this month's visit? I don't know. I haven't even been on TikTok at all today. I don't know what's going on. I know nothing. So, um, well, tomorrow I'll do my regular live and we'll kind of just talk about different stuff. But I want to thank you guys so much. 600 guys hung out this long. I so appreciate you guys hanging out. Look at you guys, almost to 300,000 likes, 270, almost 275,000 likes. Wiggle your fingers out. Thank you guys for the gifts, all the comments, the loves, the new followers. Thank you guys, everyone who's a new follower. Don't forget to follow my YT as well because I'm going to download this up. I'm going to start to download it immediately. Hopefully it'll be done by the time I'm done cooking, and then I'll put it right up on YT. So I love you guys so much. I will see you tomorrow. Have a good night. Bye.